Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, my couch potatoes. Happy Thursday. We're almost to the weekend. I'm so excited. I need more time in the day. I need more time in the day. We're getting so close to the fundraiser and so much to do. But I'll tell you what, every hour that goes by, the more excited I get. And I hope you guys are excited too about it. So for today, I'm a little bit later than normal because I had a bunch of stuff I had to do this morning. So doing another afternoon stream. Not a fan, I'll be honest. Not a fan of this afternoon stuff. It might take me a while to get used to it today. Oh, thank you, Buffy. See, I look hot. Oh my, you're just. Anyway, I won't go into what I was going to say. So we're closing up Marraccini today. Well, on what we need to know for the fundraiser, pulling it in real time, getting us caught up as to why this fundraiser needs to happen. So we'll be doing that today. And then tomorrow, it'll be normal time, 10 a.m. Myself, Terry, and I heard Winks, might be coming on for an hour and a half or so, where we're going to tell you all about the fundraiser, who's coming, when they're coming, what's being auctioned off, how much money you need to make sure is in your bank account, and how the whole fundraiser is going to work on Saturday. So in case you've been living under a rock, we're doing a 12-hour Mega-Stream Fundraiser on Saturday. That's right, 12 whole hours. For Mike Marraccini, I am going to probably have to take a few days off after that to just sleep. But I am so excited to talk about with you guys. I have had to keep so many secrets, and I'm good at keeping secrets, but not when they're fun ones that I want to share. But I've been very good about it. So we will talk all about that tomorrow. Lainey, hello. Hope you're doing well today. Pam, hope you're doing well. I already said hi to Buff. Lady in Gray, hello. April, happy to see you here again. I hope you're having a lovely day. Hey, Rob is here. One of our fundraiser guests. I'm pretty sure. I hope so. I know he said he would. If not, I'm putting you on blast. No, I'm just kidding. Thanks for stopping in, Rob. I am looking, let me tell you what, I am so excited to just I'm anxious, very anxious about it, but also excited to just be able to meet and talk to people and get to know them and their story and all of that. I'm so excited about it. Can you tell? Can you tell? Tomorrow, I'll just have a look of fear, though. It'll be like, so tomorrow's the big day. And Buffy will just be calming me down in the background the whole time. Like, it's fine. You're going to be fine. Oh, you know what I just realized? I realized my light is purple. It's normally not this color. Hold on. Let me fix that because that's weird. Boop, boop, boop. Sorry, my background's going to get real weird. I'm just so excited. There we go. Okay. There we go. Now I'm super white again, like a vampire. Anyway, where were we? Hi, Stringer Bell. Good afternoon to you. Happy to see you. Sitches, hello. You're walking the dog before it hits triple digits. Ew, sir, or ma'am, so sorry. That's horrible weather. Mm. It's June. We finally had to put in our air conditioners like the week before last. Normally we don't have to do that till the middle of June. But nope, can't do that anymore. So now I just don't go outside. But triple digits, oh my goodness. We hardly ever hit that here, thank goodness. Take some tea with honey and lemon on Saturday. Yeah, so Terry keeps telling me, well, she sent me one time a few months ago, some of that throat coat tea. First of all, I hate tea. I hate all tea. I wish I didn't. I really wish I didn't. I wish I loved tea. but I don't. And she sent me this licorice flavor. Bless her heart. She's so sweet and thoughtful, and I was just like, this is so gross. I hate this. Now, Elbow Feet did pick up a lemon flavored one of this throat coat tea thing that I'm going to drink tonight and tomorrow and probably Sunday. But you just should know I'll be complaining the whole time. That's all you need to know. He just is the only one that's going to have to deal with it. Hello, Dan Montana. Good morning to you. And thank you still for being a lurker. We love our lurkers, our live chatters, our replay crew. Y'all are important, and I'm so happy y'all are here. Hello, half-ass fashion. Oh, look at that cute little cat. Happy you're here. And I'm some lady. Good morning to afternoon to you. Oh, some of you guys, it's morning for you. I forget. Hello, Vil. Happy to see you. Hope you're having a great day. You could probably add some whiskey for a hot toddy. Oof, I don't know. I don't know about that. Whiskey and llama do not go hand in hand at all. At all. Unless you want to see like some sort of MMA fight, then maybe. But I don't I don't drink the whiskey. I've learned my lesson one too many times. Um, Buffy says tea tastes like drinking grass and flowers. It does. That's why I don't like it. And they're like, oh, you could put some milk in it. And like, I know my coffee is just bean water that I put creamer in. But something about the tea, I'm like, my Snickers flavored coffee creamer is not going to taste good with dirt and grass and leaves. So I'm glad I'm not the only one. I have heard the throat coat is very, very good. So I will be doing that. Just Pam, just choke it down like Laura. I mean, I guess we'll see what my special talent is. Jeez Louise. I drink coffee all the time too, Bill. How do I take my coffee? I use coffee creamer, some sort of flavored coffee creamer. Usually, right now I'm on a Snickers coffee creamer because I like it because it adds a little bit of like nuttiness to it. But I do not like fruit flavored coffee things. No, thank you. So I usually have like Italian sweet cream's usually my go-to coffee creamer. I can also do the sweet and something. Sweet and something that comes in the red coffee creamer is usually what I do. I will not drink black coffee. Doesn't happen. I don't use sugar in my coffee anymore. I used to have a lot of sugar in my coffee too, but I was able to cut that out and now I don't need it anymore. But I also use like a lot of creamer. How much creamer I go through a week is rather embarrassing. So you just need to know it's a lot. It's a lot. Hello, Louise. I hope you're doing well today. Thank you for joining us. Have I looked at the Lego story yet? No. So this week I've just been playing catch up since I had to take last week off, and then a whole bunch of stuff for the fundraiser on Saturday. As soon as that fundraiser is done, though, Sunday and Monday is going to be me catching up on this Lego story that everybody keeps telling me about, which I hear is wild, as well as the Mackenzie Shrilla story that I've been also told. Everybody else is like all caught up with this. And I was like, I don't know what's happening. So I am going to get caught up on that over the weekend while I lay in bed drinking awful tea, apparently. So at least I'll have that to look forward. I drink coffee with my creamer. Yeah, pretty much. Pretty much. You use half and half. That's when I have to have sugar. That's the only time. Like if I'm at, hospital or appointment and they just got your basic ass boring creamer, which come on, I'll be ridiculous. Then I got to put a lot of sugar in it. The only Lady Gray, the only break Llama has had this week was when we watched Real Housewives, and that was barely a break. I wouldn't even say that. But yeah, it's been pretty crazy this week. So you're so sick of Mackenzie. Yeah, I don't know the whole story. So I did hear that Terry and I, have the full transcript of her trial. Mm. So I'm going to look at that. I know we're going to talk about it eventually. When, I don't know, but I promise I will get caught up. Someone needs to download the Lego video before it gets taken down. Oh, oh shit, really? Okay. All right. Well, we know people that know how to do that. So, hello, Shanta. So happy to have you guys. You're a half and half girl, too. Well, that's fine, I guess. You don't like a lot of flavor in your life. Just kidding. No, I mean, it would be nice if I could cut back on the creamer use too, but one step at a time if you want to have a happy llama. So, all right, you guys. So, let's talk about where we left off yesterday. So, Laura had come up with all of these excuses of why she wanted to continue and blah, 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 blah. She didn't have a lawyer. Her dad was sick. She was sick, all this other stuff. And the judge was like, nah, girl, like we're going on with this hearing on October 21st to 22nd. So you better get your ass fucking here. And Laura does what Laura does. And on the first day of that hearing, she shows up via Zoom. And the judge is like, no, everybody better be here tomorrow. And then there was like this whole court reporter situation, right? Where like they weren't going to have a court reporter, but then Mike's team found a court reporter, a private one. And so they were going to continue on with the hearing. Well, Laura apparently is using this as her reasoning of why for her appeal and all of that shenanigans because she didn't like get to object to it or something because she wasn't on the email line. It's a bunch of bogus bullshit. Basically, um, she felt like because it was a private hired court reporter that like it was some conspiracy against her or something. I don't know. She doesn't know how anything works. Um, so then she says, she doesn't bother showing up at all the next day. So the judge, because she has a life-threatening medical emergency, she apparently has some gastrointestinal bleeding going on. She had the nurse practitioner be on the call with her and the judge is like, okay, you know what? We'll just push it out to November 5th. Fine. All right. Because she's like, I might have to do a bunch of testing, blah, blah, blah. So the judge is like, fine. Sorry, this was on the 21st, not the 22nd, like I had said. I'm pretty sure I just misspoke there. But anyway, so she has, a week and a half, 2 weeks to get her shit together. And come November 5th, she's nowhere to be seen. As a matter of fact, she claims that she is in the ER with a life-threatening emergency health issue. She was planning on driving 11 and a half hours to the hearing, which is wild. She says she booked a plane ticket, but then canceled it because she thought the court reporter thing, she wouldn't have to do anything. So then she booked a plane ticket. And then, wouldn't you know, early that morning on November 5th, she gets admitted to the emergency room and she pulls the same shenanigans that she does for literally everything else, right? Delay, an emergency comes up. Oh, I'll sign away my HIPAA stuff if you don't believe me, which we all know is a freaking joke with her because she is not that willing to turn things over. So, because she didn't show up, the judge dismissed the case, right? Frees Mike from this DVRO renewal. And Laura's pissed, of course. She feels wronged. So, come December, about a month later, she writes all these reasons of how this was unfair. She had given them medical notice, blah, blah, blah. The record wasn't correct, yada, yada, yada. And she says she's going to appeal it, which is kind of why we're here today. So that's where we caught up yesterday. I'm sure there was some stuff in between, but that's really the basis of it. I mean, her excuses for everything, it's always, once you've heard it, you always hear it. Hi, virtual juror. Happy to see you here. Another one of our fundraiser guests on Saturday, who I am so excited to have on and talk to her about things. if you haven't yet, please go like her channel, The Virtual Juror. You have a video that drops today, don't you? Virtual Juror? I think so. What is today? Or was it yesterday? Oh, farts. I don't remember. Let me know. Is it today or was it yesterday and I just missed it? She's been covering Laura with timeline stuff, and it's been very interesting because even she's picked up on things that we didn't really touch on, and it's been very interesting to learn about. So let me know which one it is. And I'm sorry, I forgot. Hi, Winks. There she is. Hi, babes. Happy to have you here. So today, but did she ever use the same photo of being in the ER this time? That's a good question. She said she included stuff in exhibits. I mean, we didn't really see that. So not sure if she did or not. 5:30 Eastern. Okay, so it is today. All right, good. I haven't missed it. So 5:30 Eastern, she's having a part 2 over on the Virtual Jurors. So go subscribe to her channel. I'll try to be in the chat. I don't, because it's a premiere, right? I might not be able to watch it till later tonight, though. We'll see. Either way, go do those things. Go do those things. So we ended December 2025. Today, we are picking up all the way to April 23rd, 2026. Now, I also forgot. Hold on just a second. I forgot people don't read the text messages I sent them. Please hold and listen to this meme video. Please and thank Okay, friends, sorry about that. Um, my kid's trying to be picked up by his dad, and he doesn't like to read text messages where I say, please call the kid and not me because I'll be live. But nobody really understands what I do. So, and I have a teenager now, and boy, does he love sleeping. Lots and lots of sleeping. So I had to go make sure he was awake and all of that. So, all right, back to what we were talking about here. So at the end of yesterday, Omar also said in one of his filings at the end that there would be this attorney fees and costs hearing in January, but that ended up getting postponed because Laura plans to appeal this. So there's a lot going on in this timeline. Remember, we're just kind of picking pieces of this out to read and go over before the fundraiser. Everything else that's involved in this part of the timeline, we will cover again when we get to it, because we put a pause on the timeline where we were in Owens v. Eckerd, getting very close to the trial. So the blog post and a bunch of other stuff was going on, and I'm just going to save that for when we touch back on this later. So today we're picking up with April 23rd, 2026, just a few months ago. Did I just see that to put hard-boiled eggs in your pocket? Oh, from the meme? Probably. Hi, Bruce. Happy to see you today. Hope you're doing well. Can't wait to hang out with you on Saturday. Another amazing person who's going to be on with us. So excited. All right. So Laura finally files this appellate ex parte application for an extension of time to file her opening brief for appeal because typical Laura needs more time. She needs more time to do everything all of the time. And I'm sure she's going to get a list of reasons why it's unfair for her to have to get stuff together to represent herself, which she doesn't have to do. All right. Now I know there's been lots of talk about Mike and about Laura and her persistence with him, right? So this DVR renewal dismissed. She didn't show up. But here she is appealing that decision because she wants him to have that permanent DVRO. Not needed, no evidence of one being needed. But these are the lengths she is willing to go against him. Someone who has been far removed from her, has his own family, has his own kids, literally probably would give anything for her to leave him alone. But she's not choosing to do that. And that, Laura, if you're listening, this is why people have a problem with you. Because at this point, this is spiteful and this is vengeful. And this is costing a family more money for your lies and your bullshit. Money that could go to their children. You are literally taking money from children, okay, for your dumbass shenanigans. So she is still taking these things this far with him. And it is of my opinion that she will continue to do this. I mean, think about it. Like her story with Mike, right? She has the TEDx talk, she has the chicken soup for the soul story. If she doesn't have this, that's literally her entire identity, all of it. Are those two things. She even said her in her own words that those were the only things she was proud of, right? So, and what's crazier, is that this DVRO was just dismissed, right? She doesn't have to admit to anything that the whole thing was a lie or any of that. She can simply just walk away. And she's choosing not to. And that's what pisses me off. Pisses me off a lot. And that's why, we are having the fundraiser because she's taken this to appeals. Appellate attorneys are very expensive, right? Mike shouldn't have to be fighting any of this. She should have just walked away, but no, she is not going to do that. I believe she's going to drag out this appeal as long as possible, make him have to hire a whole ass another lawyer. And I believe he said a few weeks ago, a month ago or whatever, that he had called around for appellate lawyers and they quoted between 20 grand and $85,000 or more if they had to do an oral argument. Well, whether or not this gets to an oral argument, I think is irrelevant because we know that Laura is going to try to take this as far as possible. So a lawyer is going to have to prepare and then just, medical emergency. Oh, never mind. I'm not going to do this. Or hopefully for all of us, her trial's happening and she's in jail. That would be great. That would be the only way I would not be upset about it. And remember, this Mike is also a witness for the state in her felony case in Arizona. The balls of this woman to pursue this when you have that hanging over one of your head is wild. And then what? If the appeal doesn't go through, she's not doing time, she can file another DVRO. Will she? Don't know. But she's willing to go this far. So I don't know. So anyway, what are you guys saying about her? What are these golf balls? Are you golfing right now? Or is that tea? I don't know. I don't know what the golf ball emoji is supposed to mean. I know. Poor Laura. She's so mistreated, so unfair. She's had the most unlucky life compared to all 8 billion of us. It's wild what happens to her. Oh, well, thank you guys. She annoys the shit out of me. Obviously, you guys can tell that. Louise says, I think she has and continues to go so hard for Mike because she might have actually felt something for him. And it's really messed up psychological disaster. I mean, that could be too. He is one of the ones that we know that did have an actual relationship with her, an abusive fucking relationship, but a relationship nonetheless abusive on her part. And let me clarify that real quick. There was a lot of emotional manipulation, all of that with him. And so I do think that plays into it some. I also think because she can't go after Clayton anymore. She can't go after Greg anymore, or at least she shouldn't, since she got charges for both of them. And the reason she filed for this renewal in the first place, according to her, was because of the internet and all the support they got. And I feel like she is also trying to punish Mike because she doesn't like the fact that so many people are rallying against all these guys and not her on the internet. And so she is punishing Mike for all of the above. I think it's a very complex list of reasons. I don't even know if she's consciously aware that that's what she's doing, but that's been my interpretation of things. So we'll see. Terry, didn't Laura already perform the oral argument? Stop it. That's a pretty good one. Buffy says, wonder if she's going to try to have him removed from court again at her criminal trial. Probably, but is her criminal lawyer going to do anything about it? No way. No way is he going to, or whoever ends up representing her is going to pull those cards. I mean, that's not everybody is David Gingras. I don't know. Oh, Disco. Oh, I'm sorry. You're very tiny on my screen right now. It looks like a T and a golf ball in front of it, but a disco. I love that disco party. Oh, because I said Ello has balls. I get it. I get it. It's Epcot. Hi, Violet. Violet says she's so desirable that everyone is trying to fuck with her. Right? Right. Vil says, I think it's about control in punishing her victims for rejecting her. Yeah, I mean, she is seriously one of the most spiteful people that I've ever come across. Like, I just don't understand how you don't just let some of this go. But thank goodness I'm not even close to being able to think like her. So, all right. So let's see why she's asking for more time. Hold on. Let me yell at my teenager real quick. I'll tell you what, parenting sometimes. Let me go double check and make sure he didn't fall back asleep. Hold on. I'm not going to put the memes on this time, but it'll take 1 second. Okay. Okay. Sorry. Summertime. Ah, love it. Love it. Okay. Let's get into this though, because I just rambled for like a half hour, but that's okay. Okay. Let's see. All right. So let's get into this. Bye, sweetie. Have a fun time. You have your phone? All right. Let me know what the plans are if anything changes. Okay. All right. Love you. Mom Llama. All right. So she says petitioner appellate Laura Owens applies ex parte pursuant to the California rules for a 60-day extension of time to file her opening brief, currently due April 28th, 2026, to and including June 27th, 2026. Now, I believe that the date that this opening brief is due by was June 29th. I think that's what you said yesterday, Say Cheese, right? I think that is when she has to have this due by, which is in just a few weeks. How she has time to do this all is mind-blowing to me. So, let's see. She says, on November 5th, 2025, Laura's request to renew a domestic violence restraining order was dismissed for non-appearance on a record that does not accurately reflect what occurred that morning. Jeez. Since that dismissal, Laura has actively sought appellate representation. In the weeks immediately preceding this filing, two sources of legal counsel who had each conducted substantive reviews of this matter declined to represent her. To the surprise of no one. She has to be like blacklisted everywhere. I know lawyers talk. I don't think there is really such a thing as a blacklist, but lawyers talk. So I'm sure there's been some buzz about her, right? Now, she says that they declined to represent her not because the appeal lacks merit, but because the facts underlying it are not in the official record. I feel like they told you this is dumb and we're not going to do it. And that's what I think. I think they're like, girl, sit down. Okay. Let it go. Sit down and move on with your life. Are you crazy? But yes. You hate Laura, just to be clear. Oh, Buffy, if you have the paid chat GPT, you can generate an argument pretty fast. Oh, I bet it does. Right? Virtual Jurist says she doesn't have a job and has parents who enable her. That's how she has the time. I mean, yeah, that's true. And yeah, it would be career suicide for people who have actual real jobs to represent her in this, but also not a lawyer. Now, both stated they would reconsider once that deficiency is corrected. Really? Really? Wouldn't they want to come on to make sure that it's corrected or no? Okay. The 60 days Laura requests are what is needed to correct that record, secure their representation. These reviewers have confirmed this appeal warrants, and prepare a brief that accurately presents what the court is being asked to decide. I have a feeling she's going to write these arguments as she would any other court ones. And it is my understanding of appellate law that none of that other stuff that usually gets brought up in court matters. That's why a lot of appeals don't go through. It has to be like very specific things for it to be taken into consideration. And I'm not a lawyer, but we'll ask some of them who will be with us tomorrow, Saturday, about that. But that's how criminal ones go anyway. So speaking of appeals overturning things, side note, before I came on, I saw some dings where Adam Montgomery has his murder conviction for Harmony Montgomery overturned. Are you effing kidding me? I'm going to look into that later. All I saw was the headline and I was like, excuse me? We watched that trial, not on this show, but when it was happening with our friends and stuff over in Discord. And what the fuck? That guy is the worst, by the way. He sucks. I'm really mad about it. So that's another thing I'll get caught up on later this week. Just send me a list, everybody, of stuff Llama has missed out on in the last 2 weeks. Because, the Supreme Court said the charges shouldn't have been joined. But what? So, like, we'll save it for a conversation for a different day. I want to read the article and the appeal first and then see what they're talking about. I only saw the headline, so I don't really have an educated opinion. But also, that guy sucks and it pisses me off. But anyway, back to this. Sorry. Side quest. All right, so the record deficiency is traceable to a specific and documented procedural problem. On December 3rd, 2025, Laura filed a motion to correct and augment the record in the San Francisco Superior Court. That motion was never contested and was never ruled upon. Okay. The following day, Lauren filed her notice of appeal, which, under settled California law, divested the trial court of jurisdiction over the pending motion. I also forgot she also used one of her reasons. Well, I filed to bar complaints against Omar and Rachel, Mike's lawyers, and that wasn't put on the record. Girl, maybe if you would have showed up, you could have put whatever you wanted on the record. Just saying. The motion has never been adjudicated in any court. As a result, the facts underlying this appeal are not before this court. Okay. The official record, 5 pages documenting a 4-minute proceeding, reflects only that Laura did not appear and the matter was dismissed. It contains no reference to the 2 written pre-hearing notifications Laura sent the court advising of a life-threatening medical condition. The court's written acknowledgments of those notifications received before the hearing began, the medical documentation she submitted, her offer of HIPAA authorization that no one accepted, the ADA accommodation requests she raised and which were denied, the ex parte communications between court staff and Marraccini's counsel from which she was entirely excluded the day before the hearing, or her formal written refusal to waive her statutory right to an official court reporter, a refusal that under the court's own written directive required the matter to be continued. I have a feeling those lawyers she talked to were just like, girl, that's not how any of this works. And she's like, but yeah. I think too, she's pissed that she didn't really get to railroad this renewal like she tried to railroad everything else as well. Plus, by this time too, remember she has the when in December, where we finished yesterday, I think it was November when she gets the 7 charges for Greg's case, the 7 felonies. I think that was in November. So homegirl is now facing 14 felony charges. And here she is doing all this stuff. I need a week to catch up. Yes, I do. Sierra Lamar case also overturned. Mother effer. Stay on track, Llama. Stay on track. There'll be other days for rants. Life threatening, you guys. Life threatening. She's not going to tell you what it was or send you stuff. She'll sign something for you to go investigate yourself. Here's the thing is if this was all happening, I would have thrown everything at the judge. I would have been like, here you go. Here's my hospital band. Here's my record of everything. Like, I wouldn't be like, well, if you want to see it, I'll let you see it. No, like if this was a serious matter, right? For if she ever actually signed a HIPAA release. Oh my gosh. Remember when she did for she was made to for Clayton and she did it wrong? That was totally on purpose. I believe it. Right? She can give out what she wants, but she's not going to do that. That way she can blame other people for not believing her. How dare the court not investigate her claims? How much did the people of California pay for her nonsense in court? I'll tell you what, between the 3 guys just themselves is almost $250,000. Or I'm sorry, $500,000. You know how I am with math. Wild. Also a demon. I hate that lady. Her and Adam Montgomery are the reasons why I do not cover kid trials if I can avoid it, because I can't handle that. Anyway, back to this. That record cannot support meaningful appellate review. An opening brief filed on it would misrepresent the proceeding it purports to address. 60 days to correct the record, obtain counsel, and brief the actual issues presented against a backdrop of active state bar proceedings against both of Marraccini's attorneys who appeared at the dismissal hearing, and new conduct by Marraccini requiring legal investigation is not a delay. It is the minimum necessary to proceed responsibly. Are you effing kidding me? So she files this in April. She filed her, I'm going to appeal in December. That is like 4 months. And you're like, yeah, but we need to correct the record. It's enough time. And I'm not doing this to delay. What legal investigation? All right, 2, the record versus what actually occurred. A, the official transcript. The reporter's transcript on appeal spans 5 pages and records the following. At 9:26 a.m. on November 5th, 2025, the court called the case, noted Laura's absence, appointed a privately retained reporter pro tempore because no official reporter was available, dismissed the matter for non-appearance, permitted Marraccini's counsel to reserve on attorney's fees, and adjourned. The entire proceeding lasted approximately 4 minutes. Seems pretty straightforward to me, but okay. Wonder how she pays for all the court costs. I don't think she pays anybody. I think that's probably part of her problem. It's probably why she's blacklisted on the list that I don't even know exists. That's just me making a funny. I don't know that to be true. Vil says, I would submit a declaration from the doctor. No one would believe her or document she submits because of her arts and crafts. Fair point. But bet your ass I'd be like just having a video the whole time. Like on. Be like, here is 8 hours of me in the emergency room. All of that. I don't know if the court would take it or not, but bet your ass I would be giving them everything. But she says state bar proceedings is totally irrelevant to her need for time. She doesn't have to do anything but complain. Right. But okay. Okay. They're so important now. Virtual Juror says, don't show, no TRO. What's so hard to understand? It's not fair, though. Virtual Juror, it's not fair. Don't you know? This is just what happens, but whatever. B, November 4th, 2025, the day before the DVRO renewal hearing. At 10:05 a.m. on November 4th, the court emailed all parties that there was a high chance no official court reporter would be available the following day, and that because this was a DVRO trial, the matter would need to be continued if any party declined to waive. So Laura relied on that representation, and she did not waive. So wait, she said it's to decline to waive. So if you say, no, I'm not going to, but she didn't waive anything. So I don't really understand. Sounds like her not waiving was just fine, but okay. Hi, Deb. Absolutely. Absolutely. Let's see. What followed was a series of communications from which she was entirely excluded. At 10:10 a.m., 5 minutes after the court's all-party emails, Marraccini's counsel emailed the court's department directly without Laura, because only she can do that, guys. Nobody else can. She can. It's fine. To inquire about securing a private reporter. That discussion continued throughout the afternoon. At 3:32 p.m., court staff asked whether the proposed reporter was certified. At 3:42 p.m., Marraccini's counsel confirmed one had been secured. And at 4:08 p.m., the court staff asked for her name and license number. Laura was not copied on any of it. She was added to the chain at 4:40 p.m. after the reporter had been identified and approved through a process conducted entirely between one party's counsel and the court. Upon receiving that communication, Laura immediately filed a formal written note objection invoking a code and California rules, documented her exclusion, and explicitly declined to waive her statutory right to an official reporter. So, okay, so she doesn't do it at the time, but later, after everything's been said, because she doesn't know how to read and what words mean, she's like, objection. No, it's not happening. Oh, is it going to storm? It got very dark. Oh. The many minutes are silent on the subject entirely. At 5:08 p.m., the first moment Laura had confirmation the hearing might proceed, her family purchased emergency last-minute air travel from Scottsdale, Arizona, where she currently resides, to San Francisco for the following morning. She transmitted the confirmation to the court that evening, as one does as late as possible. We know the courts love that. Love it. But again, she thinks this renewal is so fucking important because if she doesn't have it, Mike is this monster. All right. So she needs this because she's just so scared all the time. And she does everything she can to like not take it seriously enough to like show up. And that's why it's a joke, a complete and total joke. I mean, do DVROs prevent a bunch of stuff? Not really. All right. But she's the one claiming that she needs this to happen. So, See, November 5th, 2025, the morning of the DVRO renewal hearing. In the early morning hours of November 5th, Laura suffered a sudden and severe medical emergency. Not life threatening. Okay. She was vomiting blood and was transported to Honor Health Hospital's emergency department, where she was admitted for a procedure under anesthesia. Okay. 6:21. I like how she does not state the exact time she went to the hospital. Just putting that out there. It's just the early morning hours. Everything else she has a timestamp for, but not that. That's interesting. At 6:21 a.m., more than 3 hours before the matter was called, Laura emailed the court and all counsel describing her condition, her hospital admission, and her physical inability to appear. She submitted medical documentation and offered without reservation to execute HIPAA authorizations permitting immediate independent verification by both the court and Marraccini's counsel. Court manager Francis Yakota replied at 7:11 a.m. Email received. Thanks. I do wish it said all the best. I really do. At 6:53 a.m., Laura sent a second notification. She was being formally admitted. The procedure under anesthesia was proceeding. She was expected to remain hospitalized overnight, and she requested a continuance. What do they mean formally admitted? Like they take you back to a room. Isn't that just already formally being admitted? I don't know. Court manager Yakota replied at 7:33 a.m. Good morning, Miss Owens. Email received. Thanks. The court thus received written notice of a life-threatening medical emergency, accompanied by medical documentation and an offer of HIPAA verification, and acknowledged it in writing twice before the matter was called. No continuance was considered. Uh-oh. The verification Laura offered was never requested. The case was dismissed in 4 minutes. The reporter's transcript contains no reference to any of this. Oh no, so sad for her. So unfair. So unfair. Bill says if she wasn't offering to procure or pay for the certified reporter, why did she need to be included in the emails? Well, because Laura looks for any avenue to complain. But if she says send something herself to the court and they share it, hell to pay. Okay. Hell to pay. You remember all those fits she was throwing during Greg's case when she would email the court and they would copy it to Woodnick and them and she was saying all her bullshit? Hilarious. Hilarious. Oh, she's the worst. Terry says she should have to pay for wasting the court's time. I agree. I think she should pay for a lot of things. Get a job, Laura. Get a job. Phil, right? Because she was supposed to be on the plane at 5 a.m. before 7 a.m. That's how we know she was serious about it. Deb says, Mike is so sweet and a gentleman. He is not a threat to anyone. Agreed. Agreed. Ugh, she makes me get all pissed. It does say all the best. It's in disappearing ink. I love that. And on some lady says, using the word transported is a sneaky tell. It implies ambulance, but she would say ambulance if it was. Agreed. It was a way to say it was even more serious. I mean, listen, vomiting blood is serious. Was she? Did she induce it herself? I mean, it's just weird. It's just weird. But also, as Virtual Juror says, so scared to leave her house, yet competing in horse shows in October 22nd to 26th. Llama, what was going on those days? Is there anything in this about them? Yeah, we will. We'll hear about a witness, Kristen. We will be talking about all of that today as well. So, Violet says her parents were so worried about her life-threatening whatever, but were able to cancel the ticket in time to get a refund or even calling on behalf of her to the courts. I mean, would them saying anything make a difference? Probably not. But I'm just saying it's interesting because she's a horse princess. Horse princess. D, the consequences. Do you know what this word means, Laura? Because I don't think you do. I didn't know that word was in your vocabulary because I feel like you've never faced them before. But okay, let's see what she thinks the word consequence means. Now, the record before this court supports only one inference. Laura failed to appear without explanation. That inference is false and it forecloses the appellate review this case requires. It is also the inference Marraccini has been exploiting publicly. He has made statements both while the restraining order was actively enforced and continuing as recently as the date of this filing, characterizing himself as a victim of Laura, a finding no court has ever made. Wow. Okay. And implying that prior judicial findings have been vacated or reversed, which is likewise false. No prior finding has been vacated. The November 5th dismissal was purely procedural, entered without any evaluation of evidence or determination on the merits. Oh my goodness. The incomplete record provides no corrective account because it does not reflect the circumstances that actually produced the dismissal. So, okay. All right. She wasn't there, guys. She wasn't there. Hi, Hellville. Hope you're doing well. Happy to see you here. Right, Buff? The court of public opinion has declared Mike a victim, as well as Greg, as well as Clayton, as well as the other guys we won't mention. Everybody but you, Laura. Everybody but you. Do you know how hard it is on the internet to get everybody to pretty much agree on one thing? And that's that you suck and you're awful and you've been hurting all these people. That's not even how the internet works. But she is so awful. I have yet to find people arguing for her on the internet. And listen, people on the internet fucking love arguing about dumb shit all the time. Doesn't even matter what it is. It could be the color of a crown, okay? And they would remember the dress? You guys remember the dress, all right? The white and gold, blue and black dress that almost broke the internet. People's families torn apart. But when it comes to Laura Owens, everybody was like, girl, girl. And she has 14 felony accounts. Like, that's how bad it is. So she does not understand the First Amendment. No, she does not. She wants to keep the DVRO so he can't talk about his experience. How is that legal? Well, that's absolutely what she thinks it should mean. But even if I feel like even if Mike appeared anywhere, he could not even talk about this. And she would still be like, I feel threatened. He's disturbing my peace. And she's brought this up with all of the guys in the stuff we've covered. Same argument. It never holds any weight at all. She thinks she can say whatever she wants, including lies and slander and defamation. But if you're to speak the truth, no, she doesn't want that. No. Yes, everyone, listen to Pam and take a minute to hit the like button because I forgot to tell you how to do that. So that lets everybody know that we're live and we can get into the algorithm and all of that. Sage She says, also, the Maricopa County District Attorney thinks Mike Marraccini is a victim. Excellent point, Sage Cheese. 10 points for cheese. Exactly, right? Now, she may not have charges for it, but he's on the witness list. And they used a lot of his stuff for her investigation. So that's a lot of proof. Good enough for me, I'll tell you that. Congratulations, Laura. You broke the internet. Don't argue with me about crowns. I'll win. Bringing people together. That's true. That is true. Hi, text packet. Hope you're doing well. Happy to see you here today. Hope your day is going well. It looks like it's about to rain here. Ugh. All right. So that was her consequences, I guess, is no, I don't like it because I didn't show up and this isn't fair. Deb says all of these guys are her victims, in my opinion. Yeah, and not even just these guys. I mean, there's the other lawsuits with the horse and the construction guy and how many other things we don't even know about because she could have scared them as much as possible that they just bowed down to the command just to make it all stop. You know, I feel there's definitely more somewhere. Somewhere that just didn't make it to court. I would put good money on that. So, Terry, I now believe we are her victims too. Oh, man. Yeah. Elville says, Deb, yes, exactly. And she has more victims than these four. Agreed. Agreed. All right. 3. The motion to correct and augment the record has never been ruled upon and must be addressed before briefing. Okay. The motion to correct and augment filed December 3rd, 2025, pursuant to these California rules and civil procedure, sought to place before this court each of the categories of admitted material described in Section 2. It was not opposed or denied. It became unreachable when the notice of appeal filed the following day divested the trial court of jurisdiction. It has never been adjudicated. This court has authority under California rules to augment the record to include materials necessary to the appeal's proper determination. The materials at issue Laura's pre-hearing medical notifications and the court's written acknowledgments, her medical documentation and HIPAA offer, her formal written non-waiver of her right to an official court reporter, her denied DNA accommodation request, the ex parte communications from which she was excluded, and her emergency travel booking are not peripheral. They are the factual predicate of every issue this appeal presents. Boy, she loves listing all that stuff, doesn't she? Hi, Deanna. Welcome back. Happy to see you. Oh, going to the pool. I love that for you. I hope you have a lovely day. Don't forget your sunscreen. Okay. Callie, Lisa, hi. Happy to see you here too, babes. Hope you're doing well. Backtracking a bit, she has an eating disorder. She probably vomits blood every day. Well, yeah, that could certainly be a possibility of that, or a repercussion. It's horrible on the body. It's pretty rough. So you want a pool? I know you want a pool. You talk about it all the time. One of these days, we'll get you that pool money, Buffy. We'll get you that pool money soon. Now, where was I? Preparing an adequate motion to augment requires identifying each item with specificity. I can't, this is a word I can't say. Specificity. That's not right, but whatever, we'll go with it. Establishing provenance and authenticity and demonstrating relevance to each issue on appeal. Laura did not understand this to be the necessary path until legal counsel identified the record deficiency as the dispositive obstacle to representation in the weeks immediately preceding this filing. Well, if you hadn't talked to anybody, how did you file the first one? I don't understand. She has moved as promptly as circumstances allow. It is the foundational step without which no opening brief can reasonably be filed, and 60 days is the minimum time necessary to pursue it. Okay. Who thinks she's going to ask for more time? I don't know how appeal works, but I don't think she'll get any more time. That sweet, sweet pool money. That's right. Oh, you have a beach? Well, you are Cali, huh? That makes sense. I don't like sand, though. Sand and I do not get along. I'd rather just have a pool, but let's see. 4. Both attorneys who appeared at the dismissal hearing are the subjects of active state bar proceedings arising from their conduct in this litigation. I don't know if we have those, but I sure as hell want to read those. Like, every time she files one of these bar complaints against somebody else's lawyers, her own lawyers, baffling. And none of them have really worked in her favor. So it's wild to me that she just keeps doing it. But Laura will go to any length because of her spite. Now, prior to November 5th hearing, Laura filed California state bar complaints against both attorneys who appeared when she was dismissed. Omar Serrato, lead counsel for Marraccini, who secured the dismissal and immediately moved to reserve on attorney fees, and Rachel Juarez, associate counsel. Both complaints arose from conduct in connection with this litigation and were filed before the hearing occurred. I bet it'll be like, they went on the internet and said things. I know that my lawyer, David Gingras, runs a blog and says lots of things, but that's fine because I told him he could. But they shouldn't be allowed to talk about anything. I bet it's something like that. Now, both complaints have progressed beyond intake. Each has been assigned to a named state bar trial counsel and has required the production of specific documentary evidence in furtherance of the state bar's evaluation. Okay. The misrepresentations under investigation include public statements made by counsel about the DVRO renewal proceedings. No. Lawyers talking about their cases publicly? It literally happens every day, all the time, unless there's a gag order, which you're not getting for something like this. specifically statements about Laura's whereabouts and about whether she offered or refused to provide medical verification and offer the documentary records confirm she made. No, you don't say. A lot of public statements. All of the public statements. What kind of vapid bullshittery are we covering today? Why Laura feels she needs an appeal. All currently happening right now as of April. So it's interesting. RJ Wright, the novelist. Oh, lovely seeing you here. I've seen you in many other chats. Happy to have you. Has anyone mentioned that Laura did not file to travel to California for the November 5th court hearing? That was brought up a few times yesterday. I think it was. Could have been the day before. Either way, it definitely has been brought up because she has to do that with her felony charges in Arizona. And she didn't. So how did you book a flight and you didn't ask if you could leave? You couldn't have. I mean, you could have taken a flight. You could have went and broken the whole thing. But yikes. Yikes. Yeah, no. She gets to file an opening brief. Is it going to go far? I don't think so, but I can't wait to freaking read it. What day was it? The 29th? I think that's a day I'm not normally live. Oh, it's a Monday. Well, bet your ass I'll be reading it either that day or the next day to you guys because I can't wait. Can't wait. Hi, Tony. Happy to see you here. Excuse me. As a single woman, I have a paralyzing paralysis when it comes to making phone calls for quotes and meetings for home repairs. As soon as they realize I'm a single woman, it's automatically like 1K or more. Girl, yes, isn't crazy. I too hate making phone calls. It gives me a lot of anxiety in that sort of way. So I get it. But also, they do that shit all the time. And I'm sorry you're dealing with that. Seichi says her state bar representations are so overblown. I had a client complain. State bar asked for my evidence. They closed the case the same afternoon I sent it. I know she does it with everybody. And it's like, oh, well, they took it as intake, so everything I said must be true. Blah blah blah. And every time it's like it doesn't matter, Laura. It's so funny. She's like, "Well, I'm going to call the manager of the bar on you." Wow, Diva Gingras is dealing with the bar. Interesting. Now, the implications for this application are direct. Laura must prepare an appellate brief without counsel in a proceeding whose central facts are simultaneously under active state bar investigation against attorneys who are subjects of that investigation and who hold every structural advantage over an unrepresented party. That sounds like a you problem, Laura. Oh, well. Courts have recognized the fundamental fairness concerns this dynamic creates. Those concerns are materially heightened, whereas here, the professional conduct of opposing counsel is under active regulatory review for alleged misrepresentations about the very facts at issue on appeal. The extension Laura requests is not dilatory. It is the minimum consistent with proceeding responsibly. Is she pissed because she's pissed because she doesn't get a lawyer? But it's like, this isn't a criminal case, ma'am. Too bad. Too bad. I don't know what to tell you. Don't know what to tell you. File it. When she calls the FBI and complains about her food delivery, she says that the FBI is investigating. She's her words are so interesting, what she uses. And you know who else is going to be on the fundraiser? A spoiler sneak peek on Saturday is Jack Fox. And I am so excited to hear him talk about Laura's words that she uses and have that discussion with him. I'm so excited. I'm so excited for everybody, but I'm just like, ooh, I can't wait to hear what he has to say about those. So, objection, Your Honor. Her words are trash. Trash. Agreed. Yeah, he'll be there. So tomorrow when we're live, you can find out what time he's going to be there. So I'm not going to tell you when yet. That's your only sneak peek for today, guys. You guys are spoiled. Just kidding. 5, petitioner has diligently pursued appellate representation and faces documented financial hardship. Laura's pursuit of appellate counsel has been continuous and in good faith. Nobody fucking cares, Laura. You're choosing to do this. So, oh well. The written declarations she received in the weeks immediately preceding this filing from 2 separate sources of legal counsel, each of whom reviewed this matter substantively before concluding that the incomplete record precluded representation, are evidence of that diligence, not its failure. Okay. Again, if you don't have representation, that's a you problem. That is not the court's problem. They don't have to give you any for a case like this, but okay. Both expressly invited Laura to reapply once the record is corrected. Who believes that? Where's our lawyers at? Is this even realistic? This doesn't sound right to me, like, at all. Like, what? Both expressly invited Laura to reapply once the record is corrected, confirming that the appeal is viable and that a clear path to representation exists. Viable is interesting. Let's see. Somebody just asked me a question. Oh, Tony, is the fundraiser just a fundraiser or a fundraiser and auction? It is a fundraiser and an auction. We have lots of items, lots of guests, some really good stuff. Tomorrow we'll go live at 10 a.m. for a little tailgate party, if you will, and we'll let you all know who's going to be joining. Auction items, though we might keep some secret. I'm not really sure. I'll double check. But yeah, that'll be going on throughout the day as well. It's going to be a lot of fun stuff. Oh, Buffy's trying to get stuff done so she can come hang out on stream tomorrow. Yes. Right? Hi, Berkeley. She says, I mean, Laura, you started it and you're keeping it going. Right? No. Oh my goodness. All right, you guys in chat. I love you guys. You guys are the best. Her inability to retain private counsel is not a matter of preference. I'm sure. Laura is currently a party to a bankruptcy proceeding with a hearing scheduled before the United States Bankruptcy Court for the District of Arizona on May 14th, 2026. Because don't forget, she did go to bankruptcy court. We'll cover that when we get back to the 2025 timeline at a later date, because of course it's a shit show, like everything Laura does. The financial circumstances that necessitated that filing, meaning she doesn't have a job, are the same circumstances that have made private appellate representation inaccessible. Well, that's just too fucking bad, Laura. Too bad. Wonder, you know what you could probably do? You could probably, I don't know, get a job to pay for an appellate lawyer if it's like this important and detrimental to your safety because of the fear you have. Just saying. Maybe get a job. A 60-day extension would allow her to address that hearing, continue her search for representation, and pursue the record augmentation that must precede any meaningful briefing. Ugh. Tony, are you sure? Because I don't have much in my email. Are you sure it was to the right address? I'm not like question. Just sometimes it does get messed up. It's Tara, Tara, at TCWT Media. I haven't had anything come in about that or in my spam. So send it again and we can talk later if that's okay. I assure you, nothing has been personal. Nobody's been rejected or anything. So just go ahead and email me again and expected Llama to check her email. I actually have checked my email every day. I've sent emails. Now, once this fundraiser is over, I think I've paid my dues. No, I'm just kidding. Just kidding. No, send me something, babe. Hey, Pam, will you put the trigger for my email in the chat, please? So she can like copy and paste it or something like that. Or did you send it to Terry, maybe? I don't know. We'll work it out, babes. We'll work it out. Let's see, where was I? All right, 6. New conduct by Marraccini requires investigation and may warrant independent legal relief. Oh, okay, Laura, let's see why. Laura has identified conduct by Marraccini raising questions on 2 distinct legal theories, neither of which she can adequately evaluate without counsel. Okay, all right. First, when a renewal petition is filed before an existing order's expiration, the order remains operative pending adjudication. Laura filed her renewal petition on July 10th, 2025. The order, therefore, remained in force through at least November 5th, 2025. True. The judge said as much. Okay. Marraccini participated in public media appearances made during that period that were broadcast to a substantial national audience. Girl, you wait till it's your trial time because those numbers are going to be like 10 times higher than any episode that has been done about you anywhere. Okay. Like it is going to literally be everywhere if you go to trial. So, and this is causing you a problem. Buckle up, little lady, because her shit is going to be straightened. I mean, Law and Crime's already asked for it. It's a whole thing. Wait till the trial, people. Pay attention to this. Now, these recordings contain material falsehoods about Laura directly and irreconcilably contradicted by Marraccini's own sworn deposition testimony of January 2018. By audio recordings in Laura's possession and by contemporaneous text messages in Laura's possession, reflecting Marraccini's own words, establishing that the misrepresentations reflect not a difference in recollection, but deliberate falsehood. Okay, says the Queen of Falsehoods. I also love how she's only has this, only her, she has these things. Their broadcast foreseeably generated sustained harassment directed at Laura. Right. Okay. Second, and independently, Marraccini has made public statements beginning in the period immediately following the November 5th, 2025 dismissal and continuing as recently as the date of this filing, April 23rd, containing the same category of deliberate falsehoods, contradicted by the same deposition testimony, audio recordings, and contemporaneous text messages described above, distributed to a substantial national audience. Also, babes, it's global, in case you didn't know that. I have many overseas viewers, so it's not just national, babes. The whole world is against you. The deliberate public dissemination of materially false statements about a person made repeatedly and to a national audience is a manner that foreseeably generates sustained harassment directed at that person. constitutes conduct that destroys the mental or emotional calm of the subject of that conduct within the meaning of the family code. Emotionally calm is not a thing I think she has ever been ever in her life. Okay. I don't think she knows how to be emotionally calm, first of all. California courts have held that such conduct need not occur within the context of an existing order to constitute abuse cognizable under the Domestic Violence Prevention Act. It is precisely this category of conduct that warrants the issuance of a new protective order. Like I've been saying, this bitch is going to do it. Bet. Even though, Laura, we would all stop talking about it if you would stop this bullshit and harassing families and people. Now, determining the precise legal basis for relief and its full scope requires analysis Laura cannot responsibly undertake without counsel. Never stopped you before. Never stopped you from filing anything pro se in any of your cases ever. Right? Her feelings isn't abuse, Laura. Ugh. Put that in our lexicon, our Laura lexicon. Right? It doesn't matter the size of the audience. That is very true. But I don't know how many of you watch trials like we do, but they pull in some big numbers. They sure do. She's going to pull a Proctor McCabe and try to seal everything. I mean, she's already tried in several of these, but they've always been mostly denied. With respect, though, to medical information in Clayton's and what we've covered so far. So, Say Cheese says, I'm having a hard time understanding why the appellate court would care about stuff that didn't happen in court. Right? Like I said, I expected her to treat this as if she was talking to a regular court and instead of an appellate court, because they literally don't give a fuck about any of this. So, Berkeley says, I mean, nobody should be contacting her directly. Absolutely. I agree. Absolutely. I very much agree with that. And I don't know if she was implying that or not. I know she was very upset about comments and people, like how I just said directly to Laura. I put out a statement of my own opinion. She thinks that's the same. But no, people shouldn't, call her, email her, or any of those things. I don't even know if people really are. But if she, as you say, she freaking wanted people to talk about her by going public with Clayton. Exactly. She just thought this was going to have a different outcome. Because if it did, oh boy, she would just be everywhere. I know it. Freedom of speech. Berkeley, Nick in Sweden, Nick Starro has been on this case for a while. He has. He has. Maybe you'll hear more about Nick tomorrow when we talk about the fundraiser. So, okay, back to this nonsense. All right. 7, the balance of equities compels relief. On one side, a self-represented domestic violence survivor whose ADA accommodation requests were denied, who suffered a life-threatening medical emergency on the morning of her hearing, who notified the court in writing before the proceeding began, whose notifications were acknowledged in writing before the matter was called, who submitted medical documentation and offered HIPAA verification that no one accepted, who was dismissed despite all of this, who the day before the hearing was entirely excluded from ex parte communications between court staff and Marraccini's counsel regarding whether the hearing could legally proceed. Communications that determined the outcome of that question without her knowledge or participation, who filed a formal written objection to the privately retained reporter and explicitly declined to waive her statutory right to an official court reporter. A refusal that, under the court's own written directive, required the matter to be continued, who filed a motion to correct the record that was jurisdictionally stranded the following day and has never been adjudicated, who diligently pursued appellate representation for months and received declinations in the weeks before her deadline that identified a correctable path forward and invited reapplication once that path is taken, who faces documented financial hardship evidenced by a pending bankruptcy proceeding, who must proceed against attorneys under active state bar investigation for alleged misrepresentations about these very proceedings, and who has been subjected to sustained and documented harassment as a direct and foreseeable result of Marraccini's public conduct. She asked for 60 days, time that would allow her to correct the record, reapply for representation, and brief this appeal properly. I cannot believe how many notes, bullet points of victimhood she put in one frickin' paragraph. Are you so dramatic? Oh my God. Oh no. Oh my gosh, she is. She's a little fragile little dewdrop. Hi, Jill. Hope you're doing well today. Happy to see you here, babes. Um, Poor baby Laura. I know. It's so unfair. Yeah, that was all one sentence, guys. She makes sure she got them all in. She probably amended it afterwards. By the way, I have 24 pages of bullet points of all my other victimhoods I talk about all the time. Probably. I don't know that to be true, but I wouldn't be surprised. Oh, snap. Look who it is. It's Carmen, not Electra's here. Happy to be with you, or happy to have you with us today, babes. Hope you're having a great day. Deb says it's not ex parte if it isn't regarding the case and only about court function. Well, tell that to Laura. How is she supposed to know when she doesn't have proper representation? Geez, Deb, what about Laura? No, I agree with you. Right. She did withdraw her bankruptcy. Probably for a very good reason based on what I have learned about that so far. Is it going to keep the feds off of her family's back? I don't know. I don't know. Holy hell, that semicolon overusage hurts my brain. Where is Laura Owens? Laura Owens, are you out there? We might summon her. We miss you, Laura Owens. Where are you? Oh, wow. That was something. Okay. Now, on the other side, the scary side, she didn't put that, but I know that's what she wants to. On the other side, a party who publicly solicited and raised in excess of $50,000 for his legal representation in this matter from an online community whose members have directed sustained harassment at Laura. Uh-oh. Uh-oh. She won't be happy about now. Why isn't nobody giving me money? Where was I? Sustained harassment at Laura. Harassment that flows directly from Marraccini's public portrayal of himself as a victim, a portrayal the judicial record does not support. Actually, side note, Mike, any of these guys could have never spoken publicly about any of this. In my opinion, based on court documents, based on a lot of your own filings, Laura, I would still have the same exact opinion. As a matter of fact, their opinion wouldn't change that. It wouldn't persuade me. Okay. This is why you got 14 felony charges, girl. Okay. Because the court documents, not because one of these guys went on some podcast or whatever. You, babe, you did it to yourself. And I love to see it. Right? What should our new goal be? I don't think we've set a goal for this fundraiser. Where's he at? Hold on, just in a momento. Where is he at? $85,483. So, we're gonna have to make a good goal for Saturday. I've seen how much y'all can raise money in a short period of time. 12 hours. I think it could be amazing. $150,000 is what we're going to raise. No, that's for, I think you're replying to the Ron Owens GoFundMe. There's nothing wrong with, yeah, exactly. What's wrong with raising money for your, because nobody supports you? I'll tell you 100%. If people on the internet believed her, they probably would be raising money for her. But again, she's kind of the reason that people don't. I know we are so mean. We're all so mean and heartless. How dare we? How dare we? It's got to be enough to really piss her off. Agreed. Agreed. That's true. A lot of that has already been spent. That is very much true. I'll look for actual numbers of what it was at during this time. But anyway, we're going to raise a bunch of money and piss her off some more. So she did think, I do believe, Deb, that she thought all this would get to see things her way. And no, because it's so bad. The lies are so unbelievably true. Literally, I haven't met anybody that supports her. And listen, if you're listening and you're like, actually, I kind of support Laura Owens, I'd love to hear it. I'm not going to sit there. I'm not going to make names at you. I'm not going to make fun of you. I would really like to hear your opinion if there are people out there with it. I just have never seen with my own eyeballs anywhere on the internet that isn't suspicious that it would be Laura or her mom herself supporting you. That's all I'm saying. So, right? No one's stopping Laura for putting on her own fundraiser. That's right. I did hear that she was talking, or because she has a website too. Don't go visit it. It's not worth it. Called Justice for Laura Owens. We'll cover it eventually because it's ridiculous. But I feel like I saw somebody, I don't know if it was in Discord or something, say that she had a page reserved for a benefit concert for her. I was like, a benefit concert? Are you kidding me? What? Oh, man. Hi, Teresa S. You have a custom JFC 42-ounce Yeti arriving to donate to the fundraiser for auction. Email me, friends. If you have stuff you want to donate, please email me. Again, it's Tara, T-A-R-A, at tcwtmedia.com. And we will get back to you immediately. Or maybe you've already been in contact with Winks. If you have, that's fine. Winks and I are absolutely working together in this, but we haven't really got to talk a lot today, so I don't know if maybe she does. I don't know. Doesn't matter. If you want to help in any way, please do email us. My email's there at the bottom of the screen. It'll be in chat. It's really easy to find. You can leave it in a comment if you don't see it, and one of us will reply back with the comment for it. So that's just amazing. She's just pissed that she doesn't have a community like this. But that's what happens when you're a genuine person, Laura. So when she shut up, shut up, Violet. When she made her I Support Laura Owens website, she said she'd be singing in New York. Okay, that was the concert. Wow. Okay, CC confirms the concert that never happened. Man, on a different timeline, though. Somewhere on a different multiverse timeline, that benefit concert happened. in one way or another. Laura Palooza. Hi, Minnie. Happy to see you here. Oh, there's Elbow Feet. Hi, babes. Hello, everyone. Hope your days are going well. Make sure you like the stream so I can be a trophy husband one day. Love you all. I know. He wishes. He is my trophy husband, even though he makes all the money. Yeah, no problem. Anytime between now, Saturday. Also, write down Wink's email too, in case it's beforehand. Because once it comes Saturday, I won't be able to check a lot. So write down her email too, which was just here on the bottom. It's like Winks 5813, I want to say, at gmail.com. All right, let's hear more about her complaining about nobody will raise money for her and she doesn't like it. All right. So, Marraccini stipulated to the original domestic violence restraining order in 2018 rather than contested. The San Francisco Superior Court granted the 2020 renewal on the merits. The order remained in force for 7 years. A bunch of bullshit. Marraccini has nonetheless made public statements contradicted by his own sworn deposition testimony, of January 2018, by audio recordings in Laura's possession, and by contemporaneous text messages reflecting his own words, in which he portrays himself as the aggrieved party and implies that prior judicial findings have been vacated or reversed. Neither is true. No prior finding has been vacated. The public campaign built on those misrepresentations has generated the sustained harassment Laura now faces, financed in part by the same community that funded Marraccini's legal representation in these proceedings. How fucking dare you guys? How dare you? Marraccini enters this appeal, Marraccini enters this appeal fully funded, fully represented, and facing no cognizable prejudice from a 60-day extension of time. First of all, two of those are very false. Not fully funded, not fully represented for an appeal. So let's talk about your misstatements, Laura. Your falsehoods, because those aren't entirely true. I know, because I'm helping raise money for it. So, okay. She created this community. Shh. Can I just IG you? I don't have Instagram. Is Winks around? Is she listening? I think Winks has Instagram. Or anybody on my team have? Any of my mods? Do you have Instagram? If so, and Tony wants to hit you up on Instagram, if that's okay, can you do that? And then give me the information later? Pretty please. Hi, Barbecue Queen. Happy to see you here. Or text packet, that's fine too. I talk to text packet. So if you're willing text packet to get the information, you can send it to me later on Discord. Terry, Terry, I forgot Terry was here. Okay, Terry says, scratch that. Terry does have her own IG, Terry True Crime, and we have a TCWT one as well. So any of those people work. I don't have social media, so Terry does, and she runs all of that stuff because I don't do it, no matter how much people tempt me. All right, so the 2018 restraining order, which Marraccini stipulated to rather than contest, was supported by a sworn declaration from Karen Ilmberger, the napkin lady, a complete stranger to both parties, seated directly in front of them on their December 30th, 2016 flight to Iceland. Ms. Ilmberger, she loves fucking telling this story to anything she files ever. She's like, I'm going to tell you about the napkin lady. Ms. Ilmberger declared under oath that Marraccini was, quote, emotionally and verbally abusing Ms. Owens for a long time, that he was so menacing that I felt her life was at stake were she to stay with him. And so she wrote her stuff on a napkin and passed it to Laura. And then told her concerns to nobody else, which is a little, I don't know. You're not going to contact like security, a flight attendant to be like, hey, when they get off, maybe security can check in on them, or, there's only this like thing at the airport of the whole see something, say something. Where's the something is what I'm wondering. Okay. Now, let's see. That she was so frightened of Marraccini that she admitted her own name from the note she passed to Laura because she was afraid that he would come after me if he found the note. Okay. That account from a disinterested witness who had never met either party has never been challenged in any court. Okay. Marraccini stipulated to that order. It supported in 2018, contested the 2020 renewal and lost. It was a whole freaking talk about a 4-minute hearing. And the order stood for 7 years. The Domestic Violence Prevention Act was enacted to prevent acts of, she doesn't include this, but I'm going to, real domestic violence in their reoccurrence. I'm surprised she didn't put that in there, quite honestly. Just like her real cancer and real everything else. Its provisions are construed liberally in favor of protection. Denying this application would forfeit, through procedural attrition, the appellate rights of a petitioner whose absence was caused by a documented medical emergency acknowledged by the court itself. Well, I don't know if it acknowledged the emergency. It just said, thanks, we got it. Whose motion to correct the record was never ruled upon, and whose inability to meet the current deadline flows entirely from circumstances beyond her control. That outcome is inconsistent with every purpose the act was enacted to serve. Conclusion that for the foregoing reasons, Laura respectfully requests that this court grant a 60-day extension of time to file her opening brief, accept this application as timely filed prior to the April 28th, 2026 deadline, and grant such other and further relief as the court deems proper. Okay, so she submits this April 3rd, 2026, which is 3 days before the deadline. I'm sorry, 5 days before the deadline, because timing is everything. Last minute Laura. She does end up getting granted this. So her opening brief is due June 29th. So yes, I'm going to take a very long nap in a few days. Louise says, I love that she freaks out about Mike's GoFundMe, but not her parents' $100,000 GoFundMe for fake medical expenses. Well, not even, I mean, I don't know all the details in that because I have not gone down that rabbit hole yet. So many rabbit holes everywhere. I was saving that for like the parent bankruptcy time. So I haven't personally looked into it, but I know there's lots of talk about it. But also, her parents' income is $20,000 a month. A month. Do you know? I can bet every single person that's listening to me right now, $20,000 a month is literally life-changing. All of our bills are going to be paid. We aren't going to be in like $1.6 million of debt. Our houses wouldn't be foreclosed upon. $20,000 in income a month is how much the Owens get. That's insane. All right. Even if I had like $10,000 a month, none of those things would happen. And I'd be like, Laura, you need to shut up and sit down. I'm tired of paying for stuff. And now they're filing bankruptcy for the second time. Well, trying to avoid foreclosure on their house. So, Cece says, so her appeal is due in a few weeks. Yes, ma'am. Will she meet the deadline or ask for another extension? Ooh, that's a good question. What do you think, Chet? What do you think? Becca has thoughts, and she has a good one. She says, I don't get that in a year. Exactly. So many people don't get that a year, barely make more than that a year, maybe double, 40 grand a year or something. Like the majority of people are that way. And these mofos, $20,000 a month. I can't wait to get into all their financial stuff. Absolutely unreal. Absolutely. Yeah, it's pretty crazy with nothing, absolutely nothing to show for it. And then she's gonna bitch about a regular dude with a regular ass life and a new small family not having to get fundraisers to help fund himself against this fucking bullshit. And she has the audacity to say that after she has drained her parents dry. This is why the internet doesn't like you, Laura. That's it, savage. That's it, peasants. Yeah, that's crazy, isn't it? But when he was on the I'm assuming Ron was on the air, he was making over $83,000 a month? Oof. Yikes. Horse season lawsuits are very expensive. That's true. Wow. Well, you know what, though? They're all miserable people, so I guess maybe that's why, I don't know. Um, I wouldn't mind a kickback, that would be great if I could get, a quarter of that a month would be awesome. So, he was making over $1,000,000 a year. Wild. Oh, wild. Alright, so that was one document. Let's see, who is this from? This is another Oh, okay. This is Marraccini's motion for attorney fees and costs, memorandum of points and authority. So this was all filed on May 4th. Okay, so this is all of Mike's. We're now getting into the second part of today where we don't have much to cover, but that one, we've been quite derailed today, which is fine. I have all afternoon. It's totally fine. And so now we have Mike and Omar stepping in, basically like finishing off the case. Now, I'll go ahead and say this. This was filed. This has been withdrawn because of the bankruptcy thing, but it'll probably be refiled. I wouldn't see why not. But we're going to go through it anyway because there's some very interesting information in these motions and all of that. So we're not going to go through all of like Omar's billing stuff or the equestrian records, but we will go over Kristen Harden, a witness about her horse seed time. And then we'll end today with a Laura blog because why not? Hi, Kelly. Happy to see you here today. Hope you're doing well today, babes. Berkeley says Big Tiff Dog went over the money for their house in San Francisco. Oh, in San Francisco. The house value had appreciated $2 million in the time they lived there. And with all the hellocks, they maybe walked out with $100K. Yeah, if you want to know all about the financial stuff, because I don't know zippy zip about it, even when I do read it, I don't understand it all. Big Tiff Dog's channel, she is the financial guru. I can't wait to sit down and talk with her, like when we do get into the bankruptcy stuff for sure. But go subscribe to her channel. You might see her soon too. And if you're interested in all of that bananas, she explains it pretty damn well, quite frankly. Do I still get it? No, but that is no fault of hers. Oh my gosh. Wow, that's just crazy. Crazy. All right, so let's get into this. Oh, this is 18 pages. All right. So this is the notice of the motion for all of this. Apparently there was a hearing date. Oh, this is why I kept thinking July 20th and getting confused on the dates. Okay. both of the dates were accurate. So there was a hearing date for July 20th, 2026 regarding attorney fees for this renewal. But that has since been withdrawn for the time being. That does not affect her having to file her opening brief for appeal. So there were those 2 dates, but this date is no longer, right? Correct me if I'm wrong, Chad. No longer on the table. Or is it? I should just get a calendar just for this nonsense. Add it to my daily calendar. All right. So please take notice. I'm sorry, to petitioner Laura Owens and propria persona. Please take notice that on July 20th, 2026 at 9 a.m. or as soon thereafter as the matter may be heard in Department 405A of the above entitled court, Respondent Michael Marraccini will and hereby does move this court for an order awarding attorney fees and costs against Laura Owens in the total sum of $109,633.98. Yeah. Now remember, she files this in July. The end of everything's the first week in November. Now, what we haven't went over in this is that there's a whole lot of David Gingras in this storyline too. Whole lot. And we know that man can rack up bills real quick with his bananery, plus Laura's. So there is reasons why this number is higher than you would expect, because just like with Clayton, right? We've been tracking Clayton's bills as we've been covering it since we knew what they were. And I mean, everything was very expensive, sure. But once Gingras came on the scene, boom, $100,000 in like 2 months. So there is that fight going on during that time of whether or not he was allowed to represent Laura, blah, 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 blah. You know how they love racking up a bill. But it's very real money and very real work was done and to prepare. So 109,000 just for this renewal, right? And I'm sure there were some deals being had with that, but these are people's jobs, right? Just like with Woodnick, that was, well, we haven't gotten to the end of Clayton's case, but we do know she was awarded, or she had to pay like $150,000. And then in Greg's case, they talked about attorney fees. I don't know if we ever learned the sum total of his attorney fees. We did get something from Woodnick, and I want to say it was tens of thousands of dollars for sure. But I don't know if we got his other attorney after Woodnick's fees in there. But I believe I've heard it was like $300,000 or something. It was at least $100,000 without a doubt. I 100% believe it was around $100,000, but that much money these men have had to pay for this fucking bullshit. So crazy. Please hit the like. Terry needs more glitter. Okay, so this motion is made under the family code, blah, 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 on the ground that Laura's request to renew the restraining order was frivolous and solely intended to abuse, intimidate, or cause unnecessary delay. And that petitioner, has or is reasonably likely to have the ability to pay the fees and costs sought. And again, Omar's fees are for the renewal. This is nothing to do with appeals. With what I said earlier about Mike saying that the appellate would be $20,000 to $80,000, because that's not what Omar does. First and foremost, that's a different kind of lawyer, I do believe. So to fight the appeal and possibly her filing a new DVRO, that is completely other territory there that she is not letting go. She's willing to make him try to spend, almost another $100,000 on appeals that we all know she's not going to, be granted, but she's probably going to flake out on. Gross. Oh, you heard 313,000 for Greg? I heard that too. I just haven't seen that. but I have heard that number a lot. So that, I mean, it makes sense. He was arguing with her for years. So that number checks out to me. We know how she is. So, right, appellate is a completely separate process. So it's crazy. Me too, Minnie. Me too. She's the worst. All right. So this motion is based on this notice of motion, blah, 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 blah. And exhibits here too, the exhibit package filed concurrently, the papers and records on file, and such further argument and evidence as may be presented at the hearing. All right. So here is what they're going to talk about. And I think that this too, I think the reason, no, that's his declaration. Never mind. I'll get to it. Memorandum of Points and Authorities. 1. Procedural history and background. Oh, short and sweet. I do like Omar's writing of things. He does a very good job in his organization, and it is appreciated, sir. Petitioner Laura Owens filed a request for a domestic violence restraining order on January 9th, 2018. A temporary order issued January 10th, 2018. The parties entered a stipulated restraining order after hearing on or about July 10th, 2018. The stipulated order contained no judicial finding that Marraccini committed domestic violence. Right? Oh, my ear. Oh my goodness. Yeah, $300,000 for one guy. You know, here she is, already costing these men a lot of money, and now she wants to cost them more money to take away from their children. They're very real children. How are they going to buy their girls ponies? Just kidding. I hope to God they don't. I feel like they're like, "Ooh, yeah, no, girl, you ain't getting no pony. No, thank you." But isn't that insane? It's disgusting, is what it is. She said that she would file a new order. And I believe it. I do. I know she lies a lot, but I believe it. All right. So the 2020 renewal on July 10th, 2020, Laura filed a renewal request. On September 11th, 2020, the Honorable Sharon Reardon, Department 403, held a contested hearing at which both parties appeared pro per. The court applied the reasonable apprehension of future abuse standard and granted the request to renew for 5 years. Oh, so stupid. The record contained no findings of any DVR violation by respondent, and the 2020 renewal was based on Laura's subjective statement of fear. Remember, she's like, everybody saw him. I didn't personally see him, but my mommy, who is very trustworthy, saw him all the time out and about close to my house. And that is scary to me, even though I personally did not put eyes on him. There was a guy I thought was him, but I didn't confirm that it was him. He was just wearing a similar jacket that I had bought. You remember that? The Patagonia jacket or something like that? The 2025 renewal petition on July 9th, 2025, Laura filed a second request to renew a restraining order. On the form, Laura left blank section 4A, the box stating, quote, I am afraid or worried that the person in 2 might abuse me in the future. Oh, I think we pointed that out when we looked at it, but isn't that interesting? She marked only section 4B, alleged violations. Marraccini retained the legal law firm on or about July 9th, 2025. Between July and October 2025, Marraccini filed a response to the renewal request with 15 exhibits in opposition to Laura's motion to proceed by declaration, motion to disqualify Laura's counsel, David Gingras, a motion to vacate the 2018 order, motions in limine, a trial brief in opposition to David Gingras's motion to intervene, and for sanctions, witness and exhibit list, and supporting declarations. A lot of work went into this for her to just not fucking show up. Which is exactly what I think she's going to do with this appeal. I I hope I'm wrong and she just walks away. I would love for nothing more than for me to be wrong about this, and Mike and the other guys, they just get to live peaceful lives, never thinking of this again. I would love to be wrong. Do I think I am? No, not at all, unfortunately. On October 10th, 2025, pretrial motions resolved and trial confirmed. So on October 10th, 2025, the court resolved all pretrial motions and confirmed trial for October 21st and 22nd. The court denied David Gingras' motion to intervene. Intervention requires direct and immediate interest in the litigation. This matter is from a witness on to the litigation and is ancillary. They denied Marraccini's motion to disqualify Gingras without prejudice as premature and ruled the motion to strike and sanctions moot. The court further noted that on Laura's representation of defective service, Marraccini withdrew the Code of Civil Procedure motion. The withdrawal was a strategic election to preserve the trial dates and avoid bifurcating the proceeding. The motion had been fully prepared, briefed, and supported by exhibits and remained substantively viable. Okay. Dan Montana says if she does testify about the DVRO, she'll be facing perjury in California. I know, right? Right. Yes. Mike abused her. Pot, kettle, a meetup. Oh, hi, Wallace. Hope you're doing well. Your whole day's upside down. I know. I had other things I had to take care of this morning. So just today, tomorrow will be my normal time at 10 a.m. But happy to see you. Deb says, so let me get this straight. Anything that scares me can be cause for a restraining order. Well, according to California, for the renewal, her 2020 renewal, it was literally, do you still feel scared about this? Do you have a reasonable fear? Yes. I have personally seen him, but I feel like he's going to harass me. I fear for my life and my future, and I need this. Boom, granted. It's exactly how the transcript went. It was exactly like that. And poor Mike, he didn't have representation. It was a complete railroad. And honestly, it's kind of gross. She didn't have to prove any of her allegations about, him breaking orders because her mom saw him somewhere or something. It was disgusting, to be quite frank. It was wild. Very wild. So October 21st, 2025, life-threatening travel representation. Ooh, Omar, why don't you tell us what things are like on that side? So on October 21st, 2025, Laura appeared by Zoom only and represented to the court that travel to San Francisco for trial would be life-threatening. The court admonished Laura that she had been previously ordered to appear in person and stated her motion was improper and not before the court today. Because no court reporter was available, the court continued the matter to October 22nd, with both parties ordered to appear in person. The court stated, quote, this court will not extend or continue requests to renew restraining order with an indefinite period. Laura's October 21st email to the court invoking a life-threatening risk representation supported by letters from a nurse practitioner styling herself Dr. Colleen Green, DNP. I thought nurse practitioners aren't doctors, right? I don't know. I don't know how it works. And from a Dr. Amar Nassif. Okay, is in Exhibit 14. Ooh. October 22nd, 2025, in camera continuance to November 5th. On October 22nd, the court held an in-camera hearing on Laura's accommodation request. The court notes that request is improper and untimely. The court nonetheless exercised its discretion to grant a brief continuance to November 5th, 2025, and ordered Laura to be in San Francisco and to be in the courthouse in person for the trial. So, October 22nd through the 26th, the Scottsdale Fall Classic. Horsey time. Horsey time. So, during this life threatening time when she was supposed to be in California, she was having the worst health luck. Life threatening, guys. Well, guess what? Laura was registered as entry number 570 in the 2025 Scottsdale Falls Classic 2, a USEF National A rated hunter jumper competition held October 22nd through 26th, 2025 at Westworld of Scottsdale, Arizona, with an entry closing date of October 6th, 2025. The full factual record of Laura's competition activity, including her placements, and the contemporaneous eyewitness observations of Kristen Harden, is set out in section 3B.5 below. So they're saying, Judge, so she kind of lied about everything. She's out on horses with her life-threatening bleeding out of her mouth and maybe butthole, I don't know, on horses, competing, but couldn't make it to San Francisco and waste everybody time and money. Oh, that's interesting. Interesting. So on November 5th, 2025, Laura did not appear. Marraccini appeared in person with counsel Omar Serrato and associate counsel Rachel Juarez. The court ruled, because of the non-appearance of petitioner, Laura's request to renew restraining order is dismissed. The temporary restraining order against Marraccini is dissolved, and no written order was prepared. That's what happens. 1. Post-dismissal procedural conduct. So Laura's post-dismissal procedural conduct is set out in detail below. The factual sequence, including filings in this court, the California Court of Appeal, and the United States Bankruptcy Court for the District of Arizona, and the Maricopa County Superior Court for all of her felonies. That is a lot of courts to be in at one time. I don't know how she does it, to be quite honest. Oh, thank you, Berkeley, for the answer. DNP is Doctor of Nursing Practice, a nursing doctoral degree. Oh, okay, thank you. I did not know that. I did not know what those letters stood for. So thank you for that. Now we know. Now everybody knows. Maybe. I think so. Why not? Unless she wants to give me medical records that say it wasn't that way, but all right. So where was I? On May 1st, 2025, a Maricopa County grand jury indicted Laura on 7 felony counts, including fraudulent schemes, 4 counts of perjury, forgery, and tampering with physical evidence arising from her conduct in Owens v. Eckerd. On November 4th, 2025, November 4th. Oh, no. I just realized the dates. Is that why she didn't show up to court on the 5th? What a coincidence. On November 4th, 2025, the day before she was supposed to be in California for her DVRO renewal hearing, a Maricopa County grand jury returned a second indictment, adding 6 additional felony counts arising from similar conduct against another victim prior to her meeting Mr. Eckerd. The original charges were dismissed without prejudice and brought again in consolidation with the November 4th, 2025 indictment, plus one additional charge relating to Eckerd. I did not know the dates on those. I love this for us. Oh my gosh. You're streaming. I was able to Google. Well, I appreciate the valiant effort. Right? Make it make sense, Tony. Make it make sense. She was too sick for court, but could ride ponies. Okay. On December 8th, did she find out about those second charges like on the 4th? I assume so. I love this. And then she's going to bitch about how the record didn't reflect things correctly. Wow. Never ceases to amaze me. On December 8th, 2025, 33 days after the dismissal of her renewal petition, Laura filed a Chapter 7 voluntary petition to the United States Bankruptcy Court for the District of Arizona. On that same date, Laura signed under penalty of perjury an application to have the Chapter 7 filing fee waived, declaring, quote, I currently have no income and no ability to pay the filing fee. I am fully dependent on family for basic living expenses and cannot afford to make payments now or within 120 days. The Honorable Brenda K. Martin granted the fee waiver on December 27th, 2025. She's so dumb. Laura, not the judge. On January 9th, 2026, creditor Clayton Eckerd filed an adversary complaint for non-dischargeability of debt against Laura, pleading 2 counts. 1, non-dischargeability, which I didn't even know was a word, of the $196,076.32 in fee judgments, because that's what it's up now. So what she's ordered to pay Clayton, I understand, is incurring interest. That's so fun. I love that for her. I really, really do love that for her. I mean, is she paying anything? No, but I love it so much for her. Trey, you better sell some ponies, girl. That's all I'm saying. Sell some of those ponies. Say Cheese says, it's like she thinks her filings and statements are siloed to the case they were made. She's like, but it is. But it is. Oh my gosh, I got a lot of messages over there. Oh my. Okay. So poetic. Right. I love it. Do we know if the judge knows about her riding horses instead of being in court? Well, they're about to tell. They're about to tell that to them now. That's what we're reading. So, ooh. Excuse me. All right. And let's see. So that was the judgment for that. For willful and malicious injury and ineligibility for any discharge under section for asset transfer and concealment, destruction, or falsification of financial records, knowing and fraudulent false claims, and unexplained loss of assets. So they're like protecting, so she can't just like get bankruptcy on Clayton's, because that's the only reason she did it. Let's be honest. It doesn't work out for her. On February 12th, 2026, and this is all stuff we will go in detail at a later date, for sure. This is just like the tippy top iceberg of what had happened. On February 12th, 2026, the United States trustee filed an application for a FRBP 2004 examination and lodged a proposed order seeking to compel 3 years of tax returns, financial account statements, asset sale records, insurance, loan, storage, trust, and Cherry Tech debt records, identifying by name accounts held by Quartet Farms. These are all companies. She is a boss buff, remember. Liz Max Investments, Keybacker, Stylet. Excuse me. So this is why, who invites the federal government into their finances? Who does? She's so dumb. Like, no one wants the federal government in your financial business, okay? Because if there is one thing they are good at, it is monies and making sure that they've got all their monies, and they will prosecute you because of monies. They don't give a shit if you have a job or not. They don't care. They're very good, the feds, with monies. So she's so dumb. That part brings me joy. On February 23rd, 2026, the bankruptcy court, with Honorable Brenda K. Martin, signed an order extending the United States trustee's deadline to file an adversary complaint against a U.S. code to deny discharge. Well, on April 15th, 2026, before the Rule 2004 examination occurred, which apparently people were very pumped up for because it's basically like Laura would have to take the stand. And Queen Jennifer was asking all the questions, which, if you don't know, I have heard she is a queen for a reason and very good at her job. And she is now the trustee for her parents' new bankruptcy. Oh, I love the universe sometimes. It gives us gifts like these. So I bet they're shit in their pants. I bet that's happening. All right. So where was I? Before the examination occurred and before the United States trustee filed its Section 727 complaint, Laura stipulated with the United States trustee and Mr. Eckert to dismiss the bankruptcy case with prejudice and not to refile any bankruptcy petition for 1 year. Oh, she stipulated to something. What can that mean? Obviously, it means something very serious since, Mike stipulated, and clearly he did that because everything she said was true. So she can't file for bankruptcy for a year, which makes that interest keep on climbing. Keep on climbing. Let's see. Show me the moon bump. They are good with your money, not so much with their money. Well, tomato, tomato. Who's asking? Oh my gosh. Bobby says, my dad always said it was the IRS that brought down Al Capone, and they will come for you. Facts. Facts. So, Vil says it's also because he was awarded fees for the appeals from the Clayton petition. Oh, thank you for that extra anecdote there. I did not know that. We haven't gotten there yet, obviously, in our coverage. So, okay. But it is still collecting interest, right? Is that still a thing? Just maybe not as high as I thought it would be, or is it just like a hard, that's it? So, yes, apparently she's dealing with those. I love it. Song time. All right, 2, the case law implicating Laura's conduct. Now, Family Code Section 6344 subdivision provides that the court shall issue an order for the payment of attorney fees and costs for a prevailing petitioner. Subdivision B provides that the court may issue an order for the payment of attorney's fees and costs for a prevailing respondent only if the respondent establishes by a preponderance of the evidence that the petition or request is frivolous or solely intended to abuse, intimidate, or cause unnecessary delay. Hold on, let me pull out my check box list. Check, check, check. Sounds like all 3 of those to me, based on what we've read. Now, subdivision C requires the court to first determine, pursuant to Family Code, that the party ordered to pay has or is reasonably likely to have the ability to pay. The amended statute becomes operative January 1st, 2023. And Marraccini proceeds under subdivisions B and C. So there's an amended section that applies to retroactively to this case. Owens versus Calkins. I want to read that case just on the name. Holds that the amended version of Family Code applies retroactively to all cases pending on its January 1st, 2023 effective date. Laura filed her renewal petition on July 9th, 2025, and the amended statute governs this motion. Okay. Does that include the other ones then? Like like his bills from Randy Sue, or no? Oh, yeah. Dan Montana says Ron and Jan's new bankruptcy filing mentions that their adult autistic daughter lives with them. Ugh. Okay. Can't wait for them to have to provide documentation for that. That'd be great. Check, check, check. The frivolous standard under the section 6344. The two prongs of subdivision B are disjunctive. A fee award may issue on either frivolousness or improper purpose. The reigning California definition of frivolousness is the two-pronged test of marriage of flattery. That's an interesting name for a case. The marriage of flattery. I don't think it was very flattery, which holds that conduct is frivolous if it is either prosecuted for an improper motive to harass or to delay, or indisputably has no merit, meaning any reasonable attorney would agree it is totally and completely without merit. Not a lawyer, but I agree. The legislature adopted materially identical language, and the parallel statutory language supports applying the flattery test to the sections of inquiry. All right, this is another, we don't need to read case law. Fees incurred notwithstanding charitable funding. Oh, this seems relevant. Under California law, fees are incurred for fee shifting purposes, even where a party is not personally out of pocket. Oh. A public crowdfunding campaign is squarely within the Lolly rule. Respondent Mike Marraccini's GoFundMe campaign is disclosed in candor to the court in the Serrato Declaration. Marraccini remains contractually obligated on the fee balance. Any sums recovered will be applied first to the withstanding balance with the firm, and there will be no duplicate recovery. So it doesn't matter if they raise money or not. It still is just fine to do so. On just a second, please. Thank you. Make sure that text I just got is not super important. Hold, please. Oh, okay. Oh, wow. Okay, that's interesting. I'll have to get back to them later. Okay, sorry about that. All right, so the bankruptcy filing does not bar this motion. So Laura's Chapter 7 bankruptcy was dismissed with prejudice on April 15th, 2026 by stipulation with the United States trustee and Mr. Eckert. Laura did not obtain a discharge and is barred from refiling for 1 year. Without a discharge, no Section 524 discharge injunction has issued. The automatic stay terminated on dismissal. Okay. All right. The motion is timely. Yeah, I think we're filing this just fine. No written order signed by the court has been filed or served in this matter regarding this. Okay. Petitioner's conduct is worthy of section fees. Oh, yeah. Let's talk some shit about her and see what happens. So the two prongs of section 6344B are disjunctive. Marraccini establishes both by a preponderance of the evidence. A, objective frivolousness. Any reasonable attorney would agree the renewal petition was totally and completely without merit. Not an attorney, but agreed. The petition omitted the core element of renewal. Under the family code and this other case, a DVRO renewal required Laura to prove an objectively reasonable apprehension of future abuse, and Laura failed to do so. All she had to talk about was the internet supporting him, and he showed up to the trial even though he was subpoenaed as a witness. Now, Laura's DV 700 left section 4A blank. The I am afraid of or worried that the person and 2 might abuse me in the future, and checked only for B, alleged violations. The accompanying 15-page declaration is titled Summary of Recent Violations by Mr. Marraccini. Its 46 paragraphs address past conduct. The closing paragraphs describe how Marraccini's past acts have been absolutely terrifying and caused Laura severe emotional distress. The declaration's final substantive request is for criminal prosecution based on Marraccini's violation of the USC code for crossing lines and stuff. The 2025 petition alleges no direct interaction between the parties. The alleged recent violations cited in petitioner's 2025 declaration do not arise from any direct interaction between the parties. They center on Laura's own Arizona paternity case, Owens v. Eckerd, Mr. Marraccini's identification as a witness in that proceeding, his presence at a June 10, 2024 evidentiary hearing named as a witness, where, on Laura's own account, court security and the sitting Arizona judge declined to exclude him, and the May 2024 release of 2016 through 2017 messages. Laura declined the witness stand and the cross-examination it required. The renewal turned on whether Laura could establish an objectively reasonable apprehension of future abuse measured against conduct since the 2020 renewal. To carry that burden in the contested evidentiary hearing she herself had set, Laura would have testified live and been subject to cross-examination. Her direct examination would have been anchored in the post-2020 conduct alleged in her July 2025 declaration, conduct centered entirely on her own Arizona paternity case, Owens v. Eckerd. Now, direct examination on that subject would have placed Laura's credibility squarely in issue and opened the door to impeach material Mr. Marraccini had assembled and disclosed in trial preparation. That material included 2 purported Sutter Health MyChart messages Laura had produced as an inbound provider correspondent. Not very legitimate, it seems. One dated 8/13/2016 from John Chung Kai Chan, MD, confirming a stage 1A real ovarian cancer diagnosis. Didn't say real in there, I just added that. The other dated 8/31/2016 from Rebecca Yee, MD, confirming an oophorectomy and surgical abortion, both identified as forgeries by forensic examination. It is also contemporaneous equestrian competition records establishing Laura's active participation in show jumping during the very period she had represented as one of continuing trauma, including her champion finish at the Scottsdale Fall Classic 2 within days of her life-threatening representation to this court. Laura had docket notice of the forgery exhibit from Mr. Marraccini's 8/25/2025 response. Over 2 months before the trial she had set, she did not appear at the hearing she herself had set. Now, following a June 10th, 2024 bench trial, the Honorable Julie Mata of the Maricopa County Superior Court found in Owens v. Eckerd that Laura brought the paternity action without basis or merit, testified falsely, misled the court, altered documents introduced into evidence, and acted with improper purpose. That's right. That judge had already determined that. Now, she is not in position to put charges on somebody, right? That's not how that works. So that's why she recommended it to the DA. Like, you guys give out charges. Here's a whole list. Let's get on that. Now, on August 19th, 2024, the court entered judgment for Eckerd in the amount of $149,219.76. The Arizona Court of Appeals affirmed and awarded an additional, oh, there you go. Who pointed that out earlier? Good job. Good job. Awarded an additional $40,259.50 in appellate fees and costs by judgments entered May 6th and May 28th, 2025. So I think that's a really good look from Clayton's appeal case, because of course she appeals everything, into what we could possibly expect her to do with this appeal case, how much it would cost, all of that. It's probably going to be very identical between the two. So, oh, hi, Mallory. A lot of Jersey people here. Add me to the list. We do have a lot of Jersey people. Jersey has a special place in your heart. Yeah, we did a New Jersey trial earlier this year, the Camaro one. So we made lots of New Jersey friends who've all stuck around with us, which is amazing. So, all right. So, the Arizona Supreme Court denied review and awarded an additional $6,597.06 by judgment entered September 19th, 2025. Okay. So they just keep tacking it on because all of our shit is just bullshit. Oh, wow. You- Okay. Can you hear me now? All right. I forgot I needed something to keep playing for my headphones. I don't actually hear it. So I don't need to keep playing. It's like, what? Girl, okay. So, petitioner Laura's total fee exposure on the Eckerd litigation is $196,076.32. Now that makes a lot more sense. Okay. On May 1st, 2025, a Maricopa County grand jury indicted Laura on 7 felony counts in this case. On November 4th, 2025, a grand jury returned a second indictment, adding 6 felony counts arising from conduct against another victim prior to Laura's meeting Eckerd, dismissing the original indictment and recharging those counts in consolidation. On January 9th, 2026, just this year, creditor Eckerd filed an adversary complaint in the United States Bankruptcy Court for the District of Arizona, alleging that Laura is ineligible for discharge under this U.S. code. On April 15th, 2026, the stipulated motion to dismiss with prejudice was entered, expressly preserving the United States trustee's right to file a Section 727 denial of discharge complaint upon reinstatement. No reasonable attorney aware of this record would have prosecuted this DVRO renewal. Fair point. Fair point, Omar. Because you don't have to be crazy to read this and just realize it's all a hubbubaloo. We need a fundraiser for me to get new headphones. No, LOV keeps telling me to pick a pair out, but I forget. I'm just like, meh. Um, do I think that I'm sorry, what's this say? Anybody else wonder if Dingus has given up on Laura now that he's mourning his wife's death, that he washed his hands of Laura and all her shenanigans? I mean, I hope so. I really do. She did him no favors. They will never do him any favors. They've only I mean, he's responsible for his part too, don't get me wrong. But I would throw my phone in the ocean, get a whole new number, and just ghost everybody. That's what I would do. So, but I don't know. Right? Oh, I could totally see her blowing up Uh, but but I have all this court stuff to do, and you're supposed to work for me for free all of the time. Who cares about your grief? What about me? Mm. B, subjective improper purpose. The October 2025 timeline proves the renewal was prosecuted to abuse, intimidate, and cause unnecessary delay. Agreed. So October 6th, 2025 was the entry closing date for the Scottsdale Fall Classic. Okay. And USEA or USEF rated, A rated equestrian competition. All right. And so she had to have her, if she wanted to sign up for that, that was her last day to sign up for it. So she knew about this little horsey competition well ahead of time and told nobody about it. The competition was scheduled for October 22nd through the 26th. And remember, she also had to ask for permission to leave Arizona. I mean, she could have just left, but it would have gotten back. She'd get in trouble. Interesting. Now, on October 10th, 2025, the court resolved pretrial motions, including denial of the Gingras motion to intervene, blah, 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 blah. Then she has her life-threatening travel thing. We've already kind of been over this ad nauseum here. We get it. All right, but October 22nd through 2025, the petitioner competed and won. So Laura was present at the Scottsdale Fall Classic 2 on the very trial dates from which she had obtained a continuance based on a representation that travel was life-threatening. She entered multiple hunter and equestrian, I think it's the equestrian divisions, was photographed wearing back number 570 mid-class. Oh, girl. Ooh, they're coming with the receipts that you were there. Oh, wow. And I bet she's just like, that's not me, that's AI. And was named champion of the ORCEP Hunter Derby, riding Scirocco at 91, a horse owned by Laura. The show's producers' official Instagram account documented her on the winner's platform. Eyewitness Kristen Harden, a professional equestrian, observed Laura at the Westworld facility on October 21st, the 22nd, the 24th, the 25th, and the 26th. Ooh, girl. And declared under penalty of perjury that at no time during that window did Laura appear fatigued, distressed, in despair, or experiencing any physical issues. Rather, she appeared happy, energetic, and smiling. Okay. So then on November 5th, 2025, Laura failed to appear at the trial she had set twice been ordered to attend in person and successfully continued to that date based on her representation that travel was life-threatening. And the court dismissed the renewal. Well, Laura registered for an out-of-state athletic competition by no later than October 6th, 15 days before the 21st one, right? And she competed there. She failed to appear on the continued date that she had obtained on some medical bullshit. Laura's claim that travel to San Francisco was life-threatening is further contradicted by her established pattern of obtaining travel authorization through proper channels in other proceedings. Oh, tell us about it, Omar. Tell us more. The Maricopa County Superior Court granted Laura's motion to modify conditions of release for travel to California on September 4th through the 8th, September 10th through the 15th, and September 23rd to 26th, and granted a second travel modification motion on September 18th, 2025, for travel to California on September 18th through the 26th. Bitch, you were just in Cali literally the whole month. Laura was thus demonstrably capable of seeking and obtaining travel authorization in advance through proper channels when she chose to do so. So I love that he's pointing that out. Like, look, she knows what to do. Don't let her fool you. She knows damn well before she's like, "Oh, I didn't know I needed to do that." Yeah. Yeah, she did. You'd promise you'd be my I suppose this is about Gingras. "You promised you'd be my lawyer forever." Bam, and she's pregnant with twins, right? You know how she feels about promises. She's crazy about promises. Now, Laura filed a notice of appeal on December 4th, 2025, a Chapter 7 voluntary bankruptcy petition on December 8th, supported by a sworn indigency declaration, papers in the appellate court on January 20th, 2026, and an Arizona injunction against harassment against a third party content creator on January 20th, 2026. If you think that Laura is ever going to stop, she is never going to stop unless she's in jail and prison. Just because she doesn't have access to do all these things. I don't think she'd be stopping by choice. It would be because of access. All the evidence points to that. On April 23rd, 2026, Laura filed an ex parte application for extension of time to file opening brief in this appellate case, which the First District Court of Appeal granted the same day. The filing is a 12-page, single-spaced document drafted and signed by Laura personally in pro per. The application's conclusion at Section 8 contains a formal written notice of intent to initiate further DVP legislation or litigation against Marraccini. Quote, Laura hereby advises this court and places Marraccini on formal notice that independent of the outcome of this application, she intends to seek a new domestic violence protective order arising from Marraccini's recent and ongoing conduct. She lies a lot, but I would believe this one. I absolutely would believe this one. She'll get a prison pen pal. Berkeley says, hopefully there'd be some sort of vexatious litigant provision if she gets a deal or as part of any sentence, so she couldn't file without permission of the court. I hope. I hope. Always be filing. Right? She always be filing. Exhausting. Oh my. Exhausting this woman is. D, petitioner has the ability to pay. So for Section 6344 in Family Code, require a determination that Laura has or is reasonably likely to have the ability to pay. The record reflects the following. Let's find out why you think she's capable of paying, Omar. I don't think you're wrong. I just want to read it. Marraccini's ability to pay showing is necessarily circumstantial. Full financial discovery against Laura has not been undertaken. The cost of doing so is in a post-dismissal posture would itself exceed the fee award sought, defeating the purpose of Section 6344. Direct disclosure from Laura is also not a reliable record. Can't trust anything that B sends you. Laura has a documented pattern of misrepresenting her financial position when it serves her interest, including her sworn declaration of no income and no ability to pay the $338 Chapter 7 filing fee on December 8th, 2025. A representation contradicted by her contemporaneous discretionary expenditure on USEF National A rated equestrian competition 6 weeks earlier. The court should therefore assess Laura's ability to pay by reference to what Laura has actually been observed to do with resources, what assets she has been federally alleged to control, and the demonstrated capacity to acquire and deploy resources across the multiple simultaneous proceedings. The record on those metrics is substantial. Exactly. How does she have money for all of this nonsense? And a private attorney for her felony case as of this point. So she's saying, I don't have money to pay Clayton. I don't have money to pay the government. I don't have money. I don't have money to pay Omar. I don't have money to pay anything. But I did retain a private defense attorney. And you got to put money down for them. Because first she is given a public defender. And then somehow she came up with money for a private attorney. And I would think, I don't know, the retainer at least probably 14,000, if not more, I'm sure. But they require upfront. No, they've played this game too many times. They're like, nah, upfront. You'd pay good money to see Judge Judy's reaction to her. Oh, that would be great. Excuse me. So Laura's October 22nd through 26th participation in the USEF National A-rated hunter jumper competition at the Scottsdale Fall Classic 2 on the very dates she had told this court were too life-threatening to travel for demonstrates discretionary expenditure capacity. Hunter jumper competition at the USEF National A tier carries entry, stall, hauling, training, and lodging fees, supported by ongoing horse board, veterinary, farrier, insurance, and transportation expenses for the horse, Scirocco 91, owned by Laura. Oh, I bet that's a pretty penny. How much is it? Do we know? What is it, like $10,000 or something stupid? It's a lot for like a ribbon. I don't understand the horsey world. No offense to horsey world people. We all have our own hobbies. It's just very confusing to me. Laura's December 8th, 2025 voluntary petition checked no as scheduled AB Part 5, business related property, and disclosed no interest in any business entity. 5 weeks later, Eckerd's adversary complaint identified Quartet Farms, Lizmax Investments, Keybacker, and Stylet LLC as 4 entities Laura controls or holds beneficial interests in, and pleaded the non-disclosure as a basis for Section 727 ineligibility. On February 12th, 2026, the United States trustee filed an application for the FRBP 2004 examination, identifying the same 4 entities by name and demanding 3 years of records on each. The bankruptcy case was dismissed with prejudice on April 15th, 2026, before any Rule 2004 production occurred and before any Section 727 adjudication. I wonder why that was. I think we know why. The stipulated order preserved the United States trustee's right to file a Section 727 denial of discharge complaint upon any reinstatement. Laura did not obtain a discharge. Okay. So on December 8th, Laura swore under penalty of perjury that she currently has no income and no ability to pay the filing fee and was fully dependent on family for basic living expenses. The same sworn application disclosed average monthly expenses of $4,777.63 and recurring family contributions of $2,750 per month. So that's your allowance and your expenses are $4,000 a month? For what? What? You live in a casita. I'm sure the car's paid off. What could you even need that? Okay. Eckhardt's adversary complaint expressly contrasts that representation with Laura's previous statements made under oath. So Laura had retained private criminal defense counsel in the state of Arizona versus Owens. Okay. Joshua Colesrud of Colesrud Law entered a notice of appearance on May 28th, 2025. I don't think this is her current lawyer. We'll see. And represented Laura on a private pay basis until his motion to withdraw was filed on November 17th, 2025. Probably because she got those additional charges and he was just like, well, girl, bye. The period encompassing Laura's July 9th, 2025 filing of the DVRO renewal at issue here, the October 21st and 22nd trial readiness hearings before this court, and the November 5th, 2025 trial date. Now, Christian Looters of Guardian Law, oh, I think that's her attorney now, of Guardian Law Group, a private Phoenix criminal defense firm, has appeared as Laura's counsel of record by notice of stipulated substitution of defense counsel filed March 3rd, 2026, and remains counsel of record to date and still now. Though my opinion is that she's going to cut ties with him very quickly after this plea deal date so she can be like, I don't have the money for a lawyer and get more time. It's probably what's going to happen. Laura has continuously prosecuted and defended litigation across the San Francisco Superior Court, the California Court of Appeal, the Maricopa County Superior Court, all the criminal division, family, civil harassment, you list them all, and the United States Bankruptcy Court for the District of Arizona simultaneously. She has no money, guys. None. From Marraccini's retention of the Eagle Law Firm on or about July 9th, 2025, through the date of this filing, Marraccini has incurred merits attorney fees of $90,100. That's 180.2 hours by Omar Serrato at $500 per hour. Whew. No, it's not surprising. Not that amount's not surprising. And it's California too. So, I mean, Woodnix was around that, wasn't it? I think it's pretty, you got the experience. So fees on fees of $5,850 and paralegal fees of $9,825. Documented cost total $3,858.98 and consist of firm advance cost of $637.70, court filings for $140, BEMC reporting and video service invoice of $837.94. That's the court reporter cancellation fee for the October 22nd date. So they did still pay $800 and she didn't bother. She had a life-threatening emergency. Combs reporting invoice of $2,000, which was the full day in-person court reporter services for Heather Batista on November 5th, and Wills of Justice invoice of $243.34 for a court filing of the ex parte RFO package. Okay, the total fees and documented cost sum of $109,000 or $109,633.98. Fees sought in this motion reflect substantial voluntary downward adjustments before submission. I believe that 100%. 100%. A substantial amount of additional work was performed but was not billed, including the independently incurred attorney fees of co-counsel Rachel Juarez, which are not reflected in this firm's billing and are not being requested as part of this motion. Counsel incurred travel and lodging expenses for the in-person trial. Appearances are not reflected in the costs sought. Oh, wow. So he didn't even factor in showing up to court, because getting a lawyer to show up in court costs a pretty penny. You think the hour-by-hour cost is a lot? Going to court in person, a lot. And he said he didn't even include it in here. Wow. Wow. and are not being requested, notwithstanding their potential recovery under the family code. So basically, they're asking, to have her pay. They said this whole case was frivolous. Award us attorney fees. We've given you all the reasons why we believe this is frivolous. She does have money. Somehow she has money. She's doing all this crazy other shit. And we would like her to have to pay us. So that is, wow. Right? I mean, she can afford all sorts of people. It's crazy. Horses are expensive. Yes, they are. Berkeley says 500 hours cheap for California. I see. That's what I was thinking. Omar regularly practices in a not quite as expensive area. Well, I mean, just even for the location anyway, I would imagine it would be significantly higher. I mean, either way, it doesn't really matter. I feel like how much somebody charges. Like he clearly put in a lot of work. He was ready to go to a 2-day trial, which is also a pretty penny, right? Because we've been tracking, Woodnick's fees with Clayton, and Woodnick cut all sorts of deals as well for the guys, for Greg and Clayton. I understand. I don't know how much of a deal, but I could see it in the notes where like, oh, we're not going to charge for this one or whatever, but that is wild. He definitely gave his real expenses a haircut. Yeah. And he's what, like San Diego or something? He's Southern California. This is in San Francisco, which is quite the travel for attorneys. So yeah. Okay. So let me see what else we have here because I have to take a quick little potty break. I'm not gonna cover that. So I'm gonna take just a quick break. I got a potty. I gotta get something else to drink. And I'm gonna put on a little meme video real quick for you. So dance party. And then we'll come back. We'll read this horsey stuff from this Kristen lady. And then Laura's blog, and we will wrap it up there. But I just need a few quick minute break. And I'll be right back. So dance party it is. Which one? Let's do this one. I don't think we've done this one yet. Okay. I'll be right back, friends. Okay. friends, I'm back. I hope you had a lovely little dance party, maybe some laughs from those memes. I am a collector of all of the memes. Uh, so I hope you enjoyed that. Thank you. Oh, I definitely need that potty break, but we went a long time, so it's okay. Um, so let's, oh my goodness, a stripper pole, Buffy. This is a daytime show. Just kidding. It's not a family friendly show. Nothing I do is a family friendly event ever. So you're doing the electric slide where she's on a pole. I love that. I love that. All right. So we are going to skip a few things. We'll discuss it later on the 2025 timeline. But just to get to wrapping up today, because I do have another show tonight at 8 and a bunch of stuff. So we are going to read the affidavit of Kristen Harden, the one who says she saw her at this pony show. I know it's a horse show. I know there's a difference between the two, but I feel like every time I say pony show, it pisses her off, Laura off, and so I'm going to. You've had a lot of caffeine today. I have not had enough. I did pour myself a glass of wine, though. We've earned it. We've earned it. All right. So here's the declaration of Kristen Harden in support of Michael Marraccini. I, Kristen Harden, declare and state as following. I am over the age of 18 and competent to testify to the matters contained herein. I have personal knowledge of the facts stated in this declaration. I am submitting this declaration in support of Marraccini and the domestic violence restraining order renewal case involving Laura Owens. So I am a professional equestrian and the owner-operator of Kristen Harden Stables. I have been competing at the Grand Prix show jumping level for over 25 years. So a fellow horsey girl. Okay. I operate a training facility in Portola Valley, California, and regularly attend equestrian competitions and events throughout the country, including at Westworld of Scottsdale. On October 21st, 2025, I was at Westworld of Scottsdale for the Scottsdale Fall Classic 2 equestrian event. At approximately 3 p.m., I observed Ryan Miller, a horse trainer in the Phoenix area, riding a horse named Scirocco 91 in the covered jumper arena. Scirocco 91, I don't know if that's how you say it. I hope I'm saying it wrong because that'll piss her off too, is owned by Laura Michelle Owens. I noticed a thin female with a high ponytail and green top near Ryan during this time. Based on my observations the following day, I believe this was Laura Owens. Now, on October 22nd, 2025, at approximately 11 a.m., all right, so when she's like, I have a life-threatening illness, I saw Laura Owens at the Westworld facility. I am certain this was Laura Owens, as I had a clear view of her face and body. Laura was watching Ryan's show, Scirocco 91. During this observation, Laura was wearing a green hoodie identical to the green hoodie on the woman I had seen the day before and black leggings. Her hair was pulled back in a ponytail and she was wearing makeup. I observed Laura's demeanor and behavior during this time. She appeared happy and was smiling frequently. She did not appear to be in any distress or despair whatsoever. I found it noteworthy that Laura did not greet or speak to anyone other than her trainer, Ryan, which I thought was unusual behavior. Laura arrived in a black Hyundai Tucson with a pink license plate. Okay. I observed her going in and out of this vehicle multiple times, taking items to and from the car. Oh, Laura remained at Westworld for approximately 1 hour. While watching Ryan, I observed Laura on her phone. She was holding the phone down in front of her. On Friday, October 24th, 2025, I observed Laura at Westworld accompanied by an individual I later recognized as her mother, Jan Black. I observed Laura and Jan walking together to the black Hyundai Tucson with a pink license plate. Laura competed and several horse jumping events at the Scottsdale Fall Classic 2 equestrian competition between Friday, October 24th and Sunday, October 26th, 2025, including the USHJA Hunter 2'6" or Low Children's Adult Hunter 2'6" and or Modified Child Adult Equestrian 2'9". Laura took several first place titles between Friday, October 24th and Sunday, October 26th at the Scottsdale Fall Classic 2 equestrian event at the Westworld facility. At no time between Monday, October 21st to Sunday, October 26th, did I observe Laura looking fatigued, distressed, and despair, or experiencing any physical issues. On the contrary, she appeared happy, energetic, and smiling. I declare under the penalty of perjury under the laws of the state of California that the foregoing is true and correct to the best of my knowledge. Executed on the 30th of October, 2025. Oh, shit. So this was literally, okay, right during this time. So, Scirocco. Okay. Well, I'm going to say it wrong anyway, just because I know it pisses her off. Sorry to Scirocco the horsey, but you'll have that. Is that where the pink license plate joke's from? I guess so. Is there a reason it's a pink license plate? Like, does that mean something in the state of Arizona? Like here, if you have yellow license plates, they're called party plates. And that's because you have been charged with either a very high DUI or you've had multiple DUIs and you have to drive around with the party plates. So everybody knows you drink and drive and they're yellow. They look exactly the same as people from New York because we do have people from New York here because we're, a big college town and they look exactly the same. So, yeah. So Berkeley says, so we were making jokes about Laura competing against kids, but that category was open to adults with horses trying low jumps. Yeah. I feel like somebody had pointed to one of these days of coverage that in the equestrian world, adults and kids compete together all the time, apparently, in a lot of stuff, not everything, but in a lot, and that it's not really that weird, unlike, every other sport I can think of right now. But somebody, one of the horsey people, I don't remember who, but yeah. Yes, they absolutely do make you wear a scarlet letter on your car. I don't remember how long you have to have it for. I think that's determined by the court. But yeah, it's usually like if you either had an egregious DUI, like some serious shit, or got into a bad accident or killed somebody, you will have those. Or it used to be, I don't know if the laws are still the same, but it used to be if you had 3 DUIs, then you got party plates. So yeah. I mean, Lainey's right. I mean, it's the horse that's doing the work. So that's fair. That's fair. When Barbecue Queen says, when I lived in New Jersey, when I first got my license, I had to have a red sticker on the back of my plate. Is that to say you are a new driver? Interesting. Interesting. Berkeley says, I'm actually in favor of that sort of license plate scarlet letter. Oh, yeah. And then they're required to have a special insurance. This is without party plates, too. That I forget what it's called, but it's like outrageous pricing for insurance if you've gotten a DUI. It's a whole thing. It's an Ohio thing. I don't know. I don't remember all the rules. Haven't really had to think about it or concern myself. I do know some people that had party plates. Did they need party plates? Yeah. Did the party plates do anything? No, they did not. But that was a long time ago. Many, many years ago. All right. So that's Kristen's declaration. Now, also in this exhibit list on page 91 is apparently Laura's life-threatening email to the courts. So let's read it. This was on Tuesday, October 21st, 2025 at 4:19 p.m. Dear Supervising Family Law Judge and ADA Coordinator, I have a long cause hearing in my domestic violence restraining order matter. scheduled to begin tomorrow, October 22nd, 2025. At today's hearing, where I appeared on Zoom in Arizona, Judge Gold stated that if I do not appear in person tomorrow, my restraining order will be dismissed. Even though the court's own October 10 mini minutes state that the court strongly suggests in person appearance. Shut up. Are you? This is the loop. See, this is why you can't give this B any loopholes. Strongly suggest doesn't mean absolutely. Shut up. Which I understood to be advisory, not mandatory, because I'm a dum-dum. No, you know damn well what it meant. Shut up. And if you needed clarification, I think you probably could have asked in, any of those 11 to 12 days. I have submitted medical documentation establishing that travel or in person attendance poses a life threatening risk. My expedited request for reconsideration of motion to continue, filed on October 17th, which is attached, included a letter from Dr. Colleen Green stating that in person attendance would be life threatening for her being Laura. There is also an additional letter from Dr. Amir Nassif requesting that the court make accommodations for postponement of her required duties at this time. I got a doctor's notes, guys. Additionally, on August 5th, 2025, I filed a motion to proceed by declaration and waive live testimony because it would make me really look bad and I might catch some more felonies, which I have attached and which included an ADA accommodation request based on diagnosed autism spectrum disorder, post-traumatic stress disorder, and related medical conditions. That motion has never been ruled on. Because the court has said that non-appearance will result in dismissal of a long-standing protective order originally stipulated to in 2018, I am seeking immediate guidance or relief under the Americans with Disability Act, California Government Code, and California Rules of Court, which require reasonable accommodations to ensure meaningful access to judicial proceedings. Well, Laura, the word reasonable may not mean the same thing to you. Opposing counsel and Judge Gold's department clerk have been copied on this message to ensure full transparency and compliance with ex parte communication rules. And I'm going to abide by this one time. Thank you for your urgent attention to this matter. Respectfully, Laura. Okay, well, they don't really have to do as much as you think they have to do, Laura. Okay, okay. Sure, why not? Oh, hi, Momster, says Laura goes hard on Mike because when he discovered his old laptop, good point, and had it forensically examined, all her lies were exposed, and she is a vengeful person. Amen, sister. That's a really good observation, too. I bet that pissed her off. So, interesting. All right, so there's that. Then we're going to skip to page 196, which is all of those emails that were going back and forth. Oh, wait, no. This is something else. This is an email thread with Department 405A with Unified Family Court, Superior Court of California. Oh, confirmation that no notice of entry was served and the 7/20 hearing date reservation. Oh, you know what? Then that's not important because they're not doing anything with that anyway. Now, as I said, when we started covering this part here today, is that they did withdraw all of that we just read. Some of it will probably end up being filed again, but it was because her bankruptcy wasn't officially done with, and when that was filed, and so they withdrew it for now, because it wasn't stipulated with until May 14th, and he filed this on May 7th. So he just withdrew it for now. What that means in the future, I don't know. I'm not a lawyer. So the last thing we're going to read today, I'll tell you what, when we entered this world, so not only at this point in the timeline, May 8th, 2026, like a little over a month ago, David Gingras comes back into the mix of things on X. Laura posts a new Medium blog because Buffy and I had talked several times about how we were kind of like, oh, jealous and had FOMO that we weren't there during like the zeitgeist of all the internet happenings, right? And then they both came back into the internet around the same time. And what a wild weekend that was. In the one Discord, it was wild seeing them come back in real time. Well, Laura has things to say about being a horsey girl. She is not happy at all with this Kristen Harden lady. So let's see what dumb shit she posted on Medium, because as one does. All right, so this is her statement regarding the declaration of Kristen Harden. So remember, she's asking for an extension of time. Well, she was granted, an extension of time for her opening brief for the appeal with the DVRO renewal for Mike Marraccini. And she has time to sit here and write a Medium article about Kristen here. So priorities, obviously, she has those in whack. All right, so on May 4th, 2026, a sworn declaration signed. Oh, by the way, you know what? Amos, are you still here listening? I forgot to say hi to you. I meant to. I forgot to say hi. Hi, babe, if you're still listening. I did not forget you. I have just been for several hours now. But hi, babes. Thanks for being here. Jill says, Kristen doesn't seem the kind of woman Laura could intimidate. Also, it sounds like coming out here, I don't know what she's about to say, but coming out, I have a feeling she's basically going to call her a liar. I don't know how important this Kristen lady is in the horsey world, but considering she has her own stable, she travels all the time. I don't know if I would want to be pissing off people in the horsey world. From what I've learned, you don't want to do that. So, hi, babes. There you are. Sorry, I forgot to say that. No, I forgot to say something earlier. Lainey says she and people like her are dangerous. If they can't get their way through lies and manipulation and life ruining alone, they'll resort to violence. Eventually, that usually is what happens. It's a fine line between what she's done and murder. Honestly, yeah. Yeah. It's pretty crazy. All right. So let's see how Kristen pissed her off. So on May 4th, 2026, a sworn declaration signed by equestrian Kristen Harden was filed in San Francisco Superior Court by Omar Serrato, a counsel for Michael Marraccini. I'm going to try to read this with as much disgust as possible, because that's how I feel she was probably writing it, in support of a motion seeking $109,633 in attorney's fees against me. The underlying case involved a domestic violence restraining order I had held against Marraccini since 2018. The case was dismissed on November 5th, 2025, not on its merits, but because I was hospitalized that morning for emergency surgery. Oh, surgery instead of just a procedure. Interesting. The dismissal is on appeal before the California Court of Appeal. eventually at the end of June when I file my opening brief. To understand why the Hardin Declaration exists and what it is designed to do, you need to understand what Serrato's fee motion actually argues. Oh, can't wait for you to tell us, Laura, your interpretation when you are so bad at interpreting everything. But sure, girl. Okay. It's fine. Amos, it's fine. I just got pregnant in the time waiting for you to say hi. Are you pregnant with my twins, Amos? Oh my gosh. And you're right, it wasn't granted on its merits either. Right, Buff? Buff says, well, this should be easy to prove. Where are the surgical notes? It's a good question. His theory is not simply that my case lacked legal merit. It is that I prosecuted it in bad faith. Specifically, that I told a court my travel was life-threatening on October 21st and 22nd, obtained a continuance on those grounds, and was simultaneously competing at a horse show on those very dates. It's not quite what he said, but okay. His motion states this explicitly. Petitioner was present at the Scottsdale Fall Classic 2 on the very trial dates from which she had obtained a continuance based on a representation that travel was life threatening. So Laura, dumb Laura, he said you were present, babe. Present. You used the words simultaneously competing at a horse show on those very real dates. I know we're getting you a dictionary, babe. We're going to do that for you. But he said that you were present. They don't technically mean the same things. And you had to travel there. So there's that. But I'm just saying, October 21st and 22nd were the hearing dates. His entire improper purpose argument depends on placing me at Westworld of Scottsdale on those two specific days. The Hardin Declaration is the only evidence he has for that. Without it, the competition records, oh my God, you are such a dumb bitch. Without it, the competition records show I competed October 24th through 26, days that have nothing to do with any court proceeding. Again, woman, that is not what he said. And that is not what Kristen said. I was not at Westworld on October 21st or 22nd. I have never met Kristen Hardin. Okay, so your point. Just because you don't meet somebody doesn't mean they can't figure out who the hell you are. Like, stupid. Stupid, Laura. You're so dumb. Oh, she's going to be like, that Llama called me a dumb bitch. I don't like it. She really is, though. She really, really is. What follows is what the record shows, what Mr. Serrato was told when he was told it, and what he filed anyway. Okay, so according to her, this is her timeline, that October 21st, according to Miss Hardin's declaration to the court, it states, at approximately 3 p.m. Mountain Time, I observed Ryan Miller, a horse trainer in the Phoenix area, riding a horse named Scirocco, 91, in the covered jumper arena. Notice, Laura, it says a man was on the horse. On the horse. I noticed a thin female with a high ponytail and green top near Ryan during this time. She knows who Ryan is, obviously. Based on my observations the following day, I believe this was Laura Owens. She didn't say shit about you being on a horse, girl. The entire premise of this The observation that generates Miss Harden's subsequent identification is impossible. Neither my horse, Scirocco 91, nor I were physically present at Westworld on October 21st. Is this true? Westworld's own security footage and Mr. Miller can confirm this. How do you know? How do you know security footage can confirm this? Do you have security footage? I mean, security footage doesn't cover an entire area ever. Just because you're not on security footage, it doesn't mean you weren't there, especially at a large event like this. So, okay. But I like how she's like, you guys could go get it. I'm not going to, but you guys can do it. She does tell on herself. That she does. She claims she had to have it on the 22nd, the day after. So yes, Becca, it was life-threatening on the court dates, but not 3 to 4 days later. Sure, Jan, especially for a surgery. I am pretty sure it doesn't matter what surgery you have. It could be a ingrown toenail for all I know. And they'd be like, don't get up on a fucking horse within the first week. I mean, I don't know. I'm not a doctor, but I'm pretty sure that's exactly that conversation. Jill says she is so stupid. She doesn't realize it's almost as bad to say you competed on 24th if you were having a life-threatening medical emergency and surgery on the 21st. Yeah, it doesn't make it sound any better, Laura. At all. At all. It's just, the court just makes her so stressful while being on a horse. She is free. Okay. So apparently her horse weren't there. October 22nd, 25. Ms. Harden swears. On October 22nd, 2025, at approximately 11 a.m. Mountain Time, I saw Laura Owens at the Westworld facility. I am certain this was Laura Owens, as I had a clear view of her face and body. Laura was watching Ryan's show, Scirocco 91. Now, Scirocco 91 did not compete on October 22nd. So her sworn basis for her certainty that she watched me watching Mr. Miller show the horse describes something the show schedule makes impossible. Is showing a horse not the same as competing? I don't know. I don't know what showing a horse means. I just assumed you. Okay, there we go. All right. Hi, Elbow. I'm streaming right now. All right. I love you. Right. You can't do anything around these parts. All right. Where was I? But anyway, showing of a horse. What does that mean? I just assume the horses go around the circle. Everybody's like, ooh, look at this horse. Look at this horse. Like a ceremony. I don't know what it means. So if you know what it means, then please let me know. She says this is another example of Laura thinking that her words and actions are siloed into the venue they occurred. She couldn't imagine the court would find out about her horse competitions. Bingo, cheese. Bingo. Jill wasn't even allowed to drive for 2 weeks after you had your gallbladder removed, right? Like I don't know. It's certainly interesting. Where did we go here? Oh, there we are. Okay. The official competition records for the Scottsdale Fall Classic 2 confirm that Scirocco's 91 first class with Mr. Miller was class 9.93 and 94 on Thursday, October 23rd. Well, why does she use the word competition for one and showing different? I don't know. I do. I do think there's a beauty pageant for horses. Otherwise, why are you doing all their hair? Okay, why are you spending that much money on horse hair care if there isn't going to be a beauty pageant for horses? Oh, you know what we should do? We should host a true crime and wine time horse beauty pageant contest. Why not? Why not? I think they should have pageant for ponies. Why not? They're majestic. I'm going to look into this. It probably exists somewhere. All right, so she goes on to say, I was not there. And as with October 21st, Mr. Miller and Westworld's own security footage can confirm this. October 23rd and 24, the official USEF competition records for the Scottsdale Fall Classic to show that his first class was October 23rd. Classes 93 and 94 with Mr. Miller. I attended as a spectator. My first day of riding and competing was October 24th. Will that all be? So you had the ability to travel and walk immediately after this life threatening surgery that had to be done at that moment, that you couldn't travel to California, but you're sitting outside all fucking day at a horse show? Girl, please. You're crazy. You are miniature ponies? Yes. Yes. Well, all the ponies and horses are eligible to compete. Yes. All the hobby horses. Yes. I love this idea. Minis are so cute. They have miniature cows, they have miniature donkeys as well. They're all very cute. Llama is so pretty. I am, but you know what? I don't know if I could win a prettiest horse contest. So I got my ponytail. All right. Anyway, Instagram versus reality. Oh, great. Can't wait for Laura to educate us on how reality works. Who's excited about this? I didn't even know she lives in the same reality as us. Okay. Yes, many donkeys do exist. I tried to convince Terry True Crime to get one, and she has yet to fulfill my dream for her. So, all right. So, on October 27th, 2025, 3 days before she signed the declaration, Hardin posted a video to her Instagram describing how she came to know who I was. In it, she says, I was watching the girl ride and I was like, damn, that girl rides pretty good. Super skinny, like maybe weighs 60 pounds, but damn, that girl has a pretty good eye. And that's when the fight started. I mean, not with me, but then holy moly, the people started talking. What fight? And then I started looking on the internet. What fight? Why don't you elaborate on the important things, Laura? She watched a girl ride and went online to find out who she was. She refers to me as the girl, not by name, not as someone she recognized. Are you upset she didn't recognize you like a celebrity and name drop you on Instagram? Okay. But as a stranger whose identity she had to look up after watching me ride. This bitch used Google to figure out who I am. Wow. Okay. That would have been no earlier than on Friday, October 24th, the first day I rode, competed, which is confirmed by the USEF records. We have never met and have never spoken. Nothing about that sequence supports a sworn declaration claiming she recognized me with certainty on Tuesday, October 21st, 2 days before I set foot on the competition grounds. How would she know your face? Oh, I don't know, because it's plastered everywhere because of all the dumbass decisions you've made And, you are the anonymous woman. It's so funny, right? She wanted to be the anonymous woman, and now she's kind of mad that Kristen goes on Instagram and doesn't say her name, makes her anonymous, and it pisses her off. Oh, that's so funny. So funny. I know. She's always calling out someone else's truthfulness. Always. She doesn't like it. She doesn't like it. Ms. Harden herself put a weight on me that would be medically critical for any adult. Shut up. You're right. It would be medically credible. Like maybe weighs 60 pounds. And yet, the declaration she signed 3 days later swore I showed no signs of being fatigued, distress, and despair, or experiencing any physical issues, and that I appeared happy and energetic and smiling. 60 pounds, 87 pounds, both are very serious, Laura. Okay. And it's kind of weird that you're like, ha, ha. Like, so she was a scale, but okay. In addition to being anorexic and bulimic, I have been dealing with serious and ongoing health issues for years. The gastroenterologist appointment I was sitting outside on October 22nd was part of the treatment. The hospitalization on November 5th was part of the same picture. Now, okay, so she says, "Oh, I had this doctor thing on the 22nd because that's the earliest they could get me in." But you're just at a doctor's appointment. So, oh, okay. I thought this was also life-threatening and she couldn't travel because of it. Bruce, it seems like Laura doesn't understand the difference between an actual observation and a quick subjective assessment. Those words are too big for her, Bruce. Too big. I don't, Buffy. I don't know. I usually go inside the doctor's office for treatment, not waiting on the outside. There were no public altercations at the Scottsdale Fall Classic 2. No incidences were reported, and no show officials documented anything. The fight she describes existed entirely online within social media communities. Bet your ass I'm about to find out what this is later tonight because I need to know. Or maybe she'll tell us. So, Ms. Harden also states in the Instagram video, and then I started looking on the internet, and then the reporters started showing up and the long range cameras. And I was like, what the hell? Oh, that's interesting. No coverage of me competing at the Scottsdale Fall Classic 2 was published by any media outlets. There was no TMZ. Girl, you think TMZ would show up for your ass? Shut up. There were no reporters. There were no long range cameras. This is verifiable by anyone. A simple search of my name in connection with the Scottsdale Fall Classic 2 returns nothing because nothing was published. The only accounts that posted anything about me in connection with the show were the Justice for Clayton Instagram page and Harden's own social media, the same account from which she declared 3 days before signing the declaration, justice for Clayton is happening. And I guess she's making it up every day. Next, what Mr. Serrato knew and when. Mr. Serrato was told everything wrong with this declaration before he filed it, beginning not in January 2026, but in October 2025, the same month Hardin signed it. On October 28th, 2025, I wrote to Mr. Serrato and told him exactly where I was on October 21st and 2020 and 22nd because everybody believes you. And yet, no Ariana Huffington. I mean, oh my goodness. Oh my goodness. The paparazzi didn't cover my competition. Why not? On October 21st, I appeared in court remotely from my home in Scottsdale. On October 22nd, I was in my car outside a gastroenterologist's office in Phoenix. The address was given to him in that email, but it was 41 minutes from Westworld, where I had a 9:30 a.m. appointment that ran into the hearing. I offered him building security footage and GPS records from my phone to verify this. You don't get to authorize building security footage, ma'am. That is private. No, no. All right. Because listen, that building, Westworld Place, if cops were like, "Hey, show me your body cam footage," guess what they would say? Nope, go get a warrant. They're not just giving that shit all willy-nilly, and especially to a civilian like you. Get out of here, Laura. You're ridiculous. Oh my gosh. Wow. Okay. Yes, you know what? I can provide you can ask Kroger if I was there picking up my groceries. They have it on security camera. I'll get it for you. That's not how any of these corporations work, period. So, sure, girl. Sure. Yes, right, Jill. She can't travel, but she sure as hell could drive herself to treatment. Not even her mom driving her for something serious, a life threatening procedure. Mm. You don't have any new groceries. You just wanted to be on that camera. That's all. His response the following day, October 29th: Laura, you are facing multiple charges for perjury. Your words carry no weight with me. We will raise these issues as well as your appearance at the horse show after you claim to be in life threatening danger at the hearing next week, unless you have dismissed your petition by end of day today. I hope you make the right decision. I mean, why would anybody believe her? Duh, Laura. On October 30th, 2025, I named Kristen Harden to him specifically and told him, if you are considering relying on Kristen Harden for any assertion regarding my whereabouts, that reliance would be fundamentally unsound. I have never met Ms. Harden. She has no personal knowledge of me, my schedule, or where I was on October 22nd. It literally means nothing, Laura. Nothing. I told him he was welcome to subpoena my phone records, which would show no GPS activity near the showgrounds on October 21st or 22nd, and offered to authorize Honor Health to confirm my presence at the facility directly. And he did not respond to my offers because that means nothing. That means nothing. It's easier to believe that you're a liar because you have charges for it right now. I'm not going to do that extra work. You want people to believe you, then you show them the real proof, Laura. Oh my goodness. Now there's no GPS activity. Like, shut up. What are you saying? On January 15th, 2026, I wrote formally in anticipation of the fee motion. I attached an audio recording of my call with my gastroenterologist's office in which a staff member expressly confirms my appointment was canceled solely because the hearing with Judge Carolyn Gold had run long and I arrived too late to be seen, but that I was present. What? Shut up. I offered HIPAA authorizations for both the October 22nd appointment and my November 5th hospitalization so Mr. Serrato could obtain the records himself. I wrote that I was providing everything precisely so there is no excuse for error. Oh, I'm sure that would have just went smoothly, just like everything, right? Another day, another canceled doctor's appointment, right? Right? Why should he do her job? Exactly. Exactly. There was no response. Before filing a sworn declaration claiming I was watching my horse being shown on October 22nd, what happened? You literally just said that you first started with saying he said you were competing, and you said, "Nah, which is not what he said. But now, okay. Okay. Before filing a sworn declaration claiming I was watching my horse being shown on October 22nd, Mr. Serrato could have simply done a 30-second search to verify whether Scirocco 91 was competing on October 22nd. Literally, nobody said that. He did not. He didn't. An attorney has an ethical. Boy, boy, I can't imagine what it must be like to be ethically educated about your job from Laura Owens, the most ethical person on the planet. We're talking about fucking ethics now. Laura, shut up. An attorney has an ethical obligation to ensure that evidence submitted to a court is accurate. Oh, so are you blaming your attorney for why you provided false evidence to the courts, Laura? Is that your attorney's fault and not yours then? Or you're the one with the felony charges? That obligation does not disappear because a client provides a signed declaration. Oh my gosh. Right? Is napkin lady fake? Oh my gosh. Right, Buff? If your phone shows no movement during that time, that's just as equally as alarming. Exactly. It proves fucking nothing. It means nothing. Oh, you're correct. Say cheese. Laura's not an attorney, so she can submit fake evidence when she is forever. It's fine. It's fine. Oh, wow. Wow. I filed a complaint against Mr. Serrato with the California State Bar arising from his conduct in the proceeding against Mr. Marraccini. The bar does not publicize the details of its resolutions, and I will respect that. What? You're respecting. Okay. Okay. Okay, Laura. What I can say is that I learned on the very day he filed this declaration that my complaint had not been dismissed. Ooh, scary music. Oh my goodness. Milo V. Hardin. What does this have to do with anything? Right now we got to get Laura being a lawyer again. This is not the first time Ms. Hardin has made specific factual claims about another equestrian's whereabouts and conduct that a court rejected. Oh, okay. Well, this is kind of interesting. Hold on. I got to let Zoe out real quick. I'm not going to put memes out. I'm just going to let them hang out outside. All right. Come on, ladies. Just crazy. I also like how she didn't like file any of this stuff in court. She went ahead and put it on Medium for the whole internet to see. And she's so respectful, but she's going to make sure that everybody knows whatever this is about that we're about to do. So, oh, is that true? Say Cheese? I would imagine so. Say Cheese says, actually, Laura, if an attorney has been found to be in violation of ethics by the state bar, it is published. So, hmm. I know, right, Minnie? Laura calling out other people for submitting questionable info to a court is just rich. Girl, you got 14 felonies for this bullshit. Shut up and sit down. Sit down. Now, I'm sorry. In Milo v. Hardin, decided by the California Court of Appeal on June 4th, 2024, Hardin published social media post accusing a certified horse trainer of knowingly violating EHV1 quarantine protocols during a competition. Ooh, juicy. Just look up Tom Girardi on the state bar website. Oh, I can't wait till I can get into Tom Girardi stuff. Oh, scandalous. I have a whole spreadsheet. I know you know this because you were with us for a members only coffee date, but I do have a whole spreadsheet of celebrity court cases of all kinds, including the Real Housewives. A lot of estates are wild. I think I have like 40 of them on there so far. Obviously, there's a lot more, but that one's on the top, though. The trainer had followed proper protocol exactly. The court found Hardin's statements were false assertions of fact, not opinion, made with actual malice, and that her attempts to characterize them as rumor or secondhand information were unavailing, and she lost at both levels. Well, I guess we're going to have to read that on our own because she doesn't know how to read and interpret words, so she misconstrues everything. The pattern is the same. In Milo, false public claims about a specific equestrian whereabouts and conduct at a specific event. Here, sworn claims about mine with the added weight of penalty of perjury declaration filed in a superior court proceeding rather than on Facebook in support of a motion seeking $109,633. I love how that penalty of perjury, she was like, no, no, no. I cited Milo v. Hardin to Mr. Serrato in October 2025 and again in January 2026, along with documentation contradicting every material claim in the declaration. He had it all and he filed anyway. Well, see though, Laura, the difference between you and Kristen is that you have 14 felony counts for lying and falsifying evidence and all the other jazz. Does Ms. Hardin? Huh? Was it that serious that she accrued 14 felony charges? I don't know. It's not the argument you think it is, in my opinion. What this experience has made clear and what this declaration is a perfect example of is that simply being against me is sufficient qualification to be believed. Ms. Hardin's declaration contradicts the official competition record, her own Instagram video, and everything I put in writing to Mr. Serrato for months. He had the documentation. He had the standing offers of independent verification, and he filed it anyway. And the moment it circulated publicly, it was treated as established at fact. Because in this particular ecosystem, the willingness to add to the pile is the only credential required. Okay. Well, sure, Laura. Okay. Well, that was a lot. And so that officially catches us up. As far as I know, unless something she's been charged with 14 felonies. Exactly, girl. Like, right? So that catches us up to modern time, literally right now today, unless something broke in this afternoon that I don't know about, but I imagine if there was, y'all would have told me in chat. So this catches us up for the fundraiser on Friday. if you have taken away anything in especially yesterday and today's coverage of this, she is not going to let this go for Mike. She absolutely is not. I know we don't believe most of what she says, but I sure do fucking believe that one. And that she's very serious about that. She is going to try the appellate route. How far that goes, I don't know. We'll see, but I think she's going to give it her all. And then as soon as that falls through, I bet your ass the very next day she files a new DVRO. Now, again, we've seen this several times before where it should have no basis at all. It should just be gotten rid of. And yet, these people find themselves in months, years in court with her because she does know how to game the system. And she is going to continue doing that to him. I firmly believe that. And I wish we were gone or wrong about this, So, but I don't think we are. She doesn't think they are. Omar even wrote in his motion, he thinks she's very serious about it as well. So, if that's any reason for us to get together for 12 hours on Saturday, then let's do it. It's going to be a lot of fun. It's going to be from 12 p.m. Eastern to 12 a.m. Eastern, well, 11:59 because of YouTube's video limits. Now, on our post or community tab or whatever on our YouTube, I did ask if anyone wants to send words of support to Mike, his family, whether you want to do it in writing or you want to record like a little video for like 1 to 2 or 3 minutes, nothing longer than that, please, though. Please do. We will make sure the messages are read during the fundraiser. You can email me, tara@tcwtmedia.com, or Winks. You can hit us up on Discord or leave a comment somewhere. I'll find it. Okay. So I think we really need to show support because as much as everyone would love to believe that, what is this with my hair? Ponytail. It's funny. There we go. That makes sense. I was like, what is this? My wings getting crazy over here. I wish I could, sit there and that man would have peace. I don't think it's coming anytime soon. She has no problem having multiple court things happening. Most of them shouldn't happen. She's never fazed by it. A lot of these are happening when she has these felony charges. She does not give a fuck. All right. She may even take the plea deal. So if she takes the plea deal on the 26th, which is a few days before her opening brief is due, what could that mean? I don't know. We're officially caught up just as you caught up with the stream. Isn't that funny how that works out? So she says my Olivia Hardin opinion is about an anti-slap motion that Hardin lost, appealed, and lost on appeal. I mean, I don't even see how it's relevant. She just wanted to out all that business on the internet instead of just sitting there and shutting up. So, oh, thank you, Jill. Jill says it's great that you've organized this fundraiser, particularly with everything you're dealing with. Well, it's not just me. Winks has been helping out. Mama Bear, my team, Terry, Lady in Gray, Buffy, Amy. It's a whole group effort to make what's going to happen on Saturday work. And it's for a good cause, honestly, because this isn't over at all. And we know it's going to piss her off so much to have another fundraiser for him. She can't stand it. So it'll be a good time. Now, tomorrow, yes, clear your whole day, turn off your phone, put on Do Not Disturb, and tell people if they want to talk to you to come in our YouTube chat to get a hold of you. The only way you're responding. Tell them you're on jury duty. You've been summoned. It'll be a very, very fun time. I can't wait. Now, tomorrow, we'll be on at 10 a.m. regular time just for a little while. It's not going to be a whole day thing, maybe like hour and a half. And we're going to talk all about the fundraiser tomorrow. A little pregame tailgating party. We'll talk about who's going to be there, when they're going to be there, what we're auctioning off, how it's all going to work. I mean, we'll explain this stuff Saturday too, but let's start a little early morning party to get the buzz out and the word out. If you want to participate in any way, like I said, you can email me or Winks. We have some slots that are pretty full already. We can't add anyone more to them. just because I'm trying to do smaller panels so everybody has a good, focus. I can't corral 8 to 10 people at a time. I can manage like 4 and keep the conversation going. But get a hold of us if you need us for anything. I'm very excited about it all. With that, I'm going to go rest my voice because at 8 p.m. in 3 hours, Terry and I will be on with True Crime and Wine Time, where we will, I don't know what we're doing. I know I have a note of what we're doing, but we'll be finishing off a case. And then I do think we're going to talk about Laura Owens and auction stuff. Maybe, I don't know. Anyway, it's in 3 hours. So if you haven't, please do like this video, subscribe to our channel, hit the notification bell to all so you'll get notified whenever we go live or drop an episode. And so that way you don't miss the fundraiser on Saturday, because every minute is going to be amazing. So I'm very excited. All right, friends. Well, you all have, oh, you left some stuff for me on Discord. Thanks, babe. I will check that out here shortly. Send me the link to what? What did I miss? Either way, I'm going to get off of here. Thank you guys so much for being with me today. And until next time, go forth and be amazing. All right. All right. Bye, friends.